Okay, it looks like we have a full house today. So today's pre-argument speech is all the more important. We are familiar with your cases, your briefs, the record, sometimes more than you wish we were. So I need you to ask for that time that you need, not the time that you want. Currently, I have 8.5 hours of argument time requested. We're not doing that, okay? So, again, please ask for the time that you need, not the time that you want, understanding that even if I cut your time short, if my colleagues have more questions, I will allow them to continue. So if you argue well, you'll be able to keep talking. All right? That being said, let's call the calendar. People versus Sharif, submitted. 325 Management Statuto. Okay. 3 minutes? 3 and 3, thank you. M. Jasmine, submitted. Leibowitz versus Board of Education.
Appellate, 6 and 8.
You weren't listening, go ahead.
Respondent 4.
5 and 1 and 4. Iagnoko versus Peter. I'm messing these names up. Okay, you know who you are. Appellant. Okay.
Respondent
4, 1 and 3. People versus Jason Ortiz. Submitted. People versus Lamik Mills. 2? Thank you. 2 and 1 and 2. Walker versus Triborough Bridge.
Appellant 7 and 3.
Okay.
Respondent 5.
6 and 2. And how much did you ask for?
Respondent
5. 5. Content versus Mount Sinai.
For the plaintiff, 7 and 2.
Okay. 7 and 2 and 5. Kushner versus Carter.
Appellant, 7 and 2. Respondent 4.
6 and 2 and 6. People versus William Felix. Submitted. People versus Kian Scotland. Submitted. Artemao versus City of New York.
Plaintiff, appellant, respondent, Your Honor, 10 and 5, please.
Defendant, appellant, 82, please.
Okay, so we're going to do 7 and 2 for plaintiff, 7 for defendant, and you said 5? And 5. Remember, we can continue asking questions, okay?
Your Honor, may I reserve time for rebuttal on my appeal?
Do you have a cross appeal?
Yes, I'm defendant Salas. I have an appeal.
Okay, so 7 and 1, okay? Thank you, I missed that. Sickenger versus Sickenger.
Appellant 7 and 2.
Respondent 2.
4 and 1 and 2. People versus Christopher Salas. 5 and 2 and 5. People versus Torres is submitted. Osario versus New York Sandy 4.
Appellant request 5 and 2, Your Honor.
Okay.
Respondent 4, Your Honor.
5 and 2 and 4. People versus Frazier. Submitted. Davis versus Brookfield Properties. Okay. It looks like you scared away the respondent. You still want to argue? Thank you. Wait until the rest of the call before you leave, okay? Submitted. People versus Luis Felipe R.
For appellant 5 and 2, Your Honor.
Okay.
Respondent 5 and
5 and 1 and 5. Magna Equities. 2 cases will be heard together.
Appellant on the 2020 appeal, 8 and 4, please.
I believe I gave permission for a late request of time, and I capped both of you at 5 minutes. Am I incorrect about that? Okay, so your request is what?
I was 8 and 4 on the 2020 appeal.
We're doing both of them together.
8, 4, and 2.
How 8, 4, and 2? We're doing them together. So you get an appeal time and a rebuttal time.
I would do 8
And you? 5 and 1 and 5 and 1. Okay, first case on the calendar, 325 Management Statuto. Counsel, you may proceed, ma'am.
Please, the court, my name is Daphne. Sorry, my name is Daphne Zakaria for Danielle Statuto. This is a case of essentially, if it stands as is, rewarding warehousing. There was a the subject building is built in 1902. There was 20 residential units.
Why don't we cut straight to the precise issues here,
The
right?
precise issue is that the subject building has never changed, other than the fact that it was warehoused. So in the sense that there are 10 housing accommodations,
Is there any evidence that any of the apartments on the 4th or 5th floor during the time period when
Yes.
rent stabilization laws were in effect have ever been used as a housing accommodation?
the fact that they,
Answer my question and then you can make your argument.
right, no,
Okay.
they have been warehoused. They have been
Well,
warehoused.
that is your conclusion.
No, that unless there is evidence, it doesn't have to be used as a housing accommodation, it has to exist as one. And to
It has to what?
exist as a housing
And
accommodation.
what case law says that its existence, without it being actually used or intended to be used, as the case law says, let me finish my statement because I'm sure you can't read my mind, says that that it permits the classification of a housing accommodation where there is no evidence that it has ever been so used.
The fact that it wasn't used doesn't go against the case law. Case law saying that it was used has long been established, but the fact of the matter is that these housing accommodations did exist. The 1979 alt resulting in the 1981 C of O doesn't change the fact that the housing accommodations remain the same. The housing accommodations being warehoused, the court shouldn't reward the warehousing behavior as a vehicle to.
Where is it? In 1937,
In
when the C of O says not using the 4th and 5th floor, how does that equate to you saying warehousing? Where is that coming from? That's your characterization, correct?
No.
Nothing, no one has testified about warehousing. There's no documents that say warehousing. There's a 1937 C of O that says 4th and 5th floors are not going to be used.
However, there were 10 housing accommodations upon inspection, and they were left vacant. That's what that C of O says. They were
Right.
left vacant. They
But
didn't.
that's not, you're saying something completely different.
I'm
You're
saying-
saying somebody warehoused those.
I'm
They
saying
don't come,
they-
they don't
they
become
eith-
warehoused.
I'm saying there were.
It helps if you let the judge finish talking. okay?
Right. That's what I'm trying to figure out. Where is your characterization of warehousing coming from? Someone had to actually do that, and I'm asking you what evidence you have of that.
What I'm saying is, it doesn't matter if it was warehoused or empty. The fact that there were 10 housing accommodations requires that this apartment be treated as stabilized.
Okay, thank you.
Thank
You're
you,
out of time.
I'm sorry.
Good afternoon, Your Honors.
afternoon.
Magda Cruz for the Respondent 325 Building Management Corporation. Your Honor, let me cut to the chase. Obviously, there's been no warehousing here. The 1937 Certificate of Occupancy, at page 113 of the record, very clearly says and directed back then, more than 85 years ago, that these apartments on the top 2 floors were to remain vacant.
Ms. Cruz, when was the last time that these apartments were occupied as living quarters?
The building was converted in 1981 to a 4-unit building. So in 1981, that space became 1 apartment on each of the top floors.
But before 1981, when was the last time?
Before 1981, we have, at least in the record, there is a document by the HPD in which an inspector in 1937 says that this is a 2-family dwelling. It found that those spaces on the top floor were vacant. This is page 148.
Because in essence, the person who purchased this building decided to have just one tenant on the second floor, and they occupied, or the second floor and the third floor,
Right.
and the first floor was commercial.
Correct. That's what the records show. And my adversary contends that these very same records, it took me a very long time to read this, as I'm sure it must be very difficult for you as well, that at some point in the turn of the century, there were 20 families in this building, and that at some point in 1913 or so, there were, those spaces on the top floor had 4 apartments each. However, after that time, in the intervening 100 years, there was a conversion done to this building so that on the dates, the relevant dates that rent stabilization coverage would have occurred, this building had 2 units. It was a 2-family dwelling in 1960.
Well, it had 2 units that were occupied and used as housing accommodations.
Correct, Your Honor. Correct, to be very precise. And there is no evidence in this record at all, not even an allegation, that there was anybody living illegally on those top floors. It would have been illegal because the C of O said that those units had to be vacant. And in 1981, the building was converted, this is after the ETPA, to a 4-unit building, so that, in conclusion, this building, my client's building, has never been subject to the rent stabilization law. It has always been less than 6 units. For that reason, Your Honor, I respectfully request that the lower court order be affirmed as correct. Thank you.
Thank you both. Leibowitz versus Board of Education. You may proceed, counsel.
Good afternoon, Your Honors. Jimmy Wagner for the appellant. If it may please the court, the underlying agency determination and the lower court's decision must be vacated and annulled for 3 primary reasons. The first reason being, they admit in the record they used the wrong standard. New York State has never adopted the minimal burden standard that was exercised by the respondents in this case. New York State has always been a significant burden standard. The second fatal flaw by the respondents in this case is they ignored New York City human rights law. New York City human rights law demands an employer engage in a cooperative dialogue with an employee when an accommodation is requested. That had never occurred in this record. It never happened. In fact, the employer says, we weren't required to engage in a cooperative dialogue with every single employee. However, the law says they were. The third fatal flaw violated by the employer respondent in this case is that they failed to follow their own promulgated rules. Not only did they fail to follow their own promulgated rules, they acknowledged they failed to follow their own promulgated rules. They said there was an emergency, and that emergency permitted them to ignore the law. However, while the COVID pandemic was happening, the governor and the mayor had ample opportunity to suspend numerous laws. We know the governor suspended statute of limitations. We know the mayor suspended street parking so restaurants could put these sheds out there. What the mayor and the governor did not suspend was the cooperative dialogue portion of the law, nor did the mayor or governor suspend their own promulgated rules, which DCAS had submitted when people are requesting an accommodation. This tenured teacher worked 2 years. She did everything that was requested of her. When the city implemented a COVID-19 mandate of the vaccine—
So is your argument that the city had to conduct 3,300 plus of these individualized accommodation assessments in addition, and that was just for the religious exemption, in addition to the thousands of requests for medical reasons? So they had to do that analysis for everybody, for every single person, as opposed to doing as they did, dealing with a set policy for this overarching emergency.
Your Honor, that's not my argument. That's the law. The law requires the city as an employer to engage everybody in an individualized accommodation process. Furthermore, the law states that it's a significant burden. If we look at the record on page 80 and the record on page 250, the city acknowledges they used the wrong standard. It was never a minimal burden standard. The city should have used significant burden standard. So even if this court was to consider the hearsay statements, even if the court was to give this special exemption to the city, it's irrelevant because the city followed the wrong law. It's a significant burden standard, not the de minimis standard that the city applied.
Okay. Is that it? All right. You may proceed.
Good afternoon. May it please the court. Chloe Moon on behalf of the respondents. As discussed at oral argument here just 2 weeks ago in Hogue, the scope of this court's review is narrow, and there was no question that DOE had a rational basis to deny Leibowitz's accommodation request on the grounds of undue hardship. That rational basis is clear from DOE's initial denial, from the citywide panel denial, and from DOE's.
Counsel, did DOE ask the petitioner to submit information about her request?
Yes, absolutely. There was a back and forth.
There was a back and forth.
Yes,
correct?
absolutely. So both the policies were established and publicized, but also there was an explicit back and forth with this petitioner.
And she was seeking to teach grade school remotely, correct?
Correct.
After all the teachers had come back into school.
Correct. And that was, sorry.
That was the accommodation she wanted.
Yes, that is correct. And
as I think probably the other 3,000 teachers also wanted, right?
Exactly.
So the question then was it arbitrary and capricious to say, I can't do that accommodation, we need to do in-person learning?
Correct, Your Honor. And DOE's position statement lays it out quite clearly that even alternative like social distancing or mask wearing or frequent wouldn't have protected the students in the way that was required by this in-person teaching. And that's made clear in the position statement.
Am I correct that the vaccination for children had not yet been had not been approved nor disseminated?
That is correct, Your Honor. If the court has no other further questions, we'd ask this court to affirm. Thank you so much.
Thank you. You have a minute.
And part of the reason I had requested additional time on rebuttal was just because of the facts that are being presented to this court that are not in the record. There is nothing in this record that says 3,000 teachers applied for accommodation. What's in the record, and it was expressed at oral argument at the lower court, it's 500 teachers of 90,000 teachers that applied for an accommodation. The accommodation requested was never discussed. If there had been an accommodation discussion in reference to the accommodation request, all of these things could have been explored. The cooperative dialogue never happened. The law demands the cooperative dialogue happen prior to the denial. No discussions of any type happened. Furthermore, this teacher's first religious accommodation procedure policy was put in place in Kane versus de Blasio. The Second Circuit ruled that it was constitutionally suspect. This particular appellant has never had a legitimate opportunity or ability to apply for a religious accommodation. The first time around, it was constitutionally suspect. The second time around, the city admits they used the de minimis standard. New York State and New York City have never, at any time in our history, adopted this minimal standard.
Thank you. Thank you so much. Iagnoko versus Petrasum. You may proceed.
Good afternoon. I'm Ambrose Richardson. I represent the appellant Pierre Iagnoko. The decision below said that the letter to Mr. Iagnoko should have apprised him, if he had made the proper inferences, that the will was missing. The original will was missing. We think it was misleading. First of all, the letter said the court requested the waiver. Secondly, it said that under a trust he would get a certain bequest. Then it said that if he signed the waiver, they would be permitted to file a copy. It doesn't say what kind of copy. It could be an original copy. It could be a signed copy. It could be a photocopy.
He consulted with counsel, correct?
He did, and I think...
And he had an opportunity then, through counsel, to seek clarity on any issue that was of concern or not clear, right?
Right, and I think lawyers are considered to be omniscient. They answer the questions that are asked to them. He had an opportunity to ask questions if he knew there were questions to be asked. There was nothing that really apprised him that he was a distributee, although if he were sophisticated, he might say, oh, they're asking for a waiver. That's because I'm a distributee. How many individuals actually know this?
Again, counsel, he consulted with an attorney.
Okay.
And certainly I presume, that the attorney read this letter.
We don't know that. We did know that
We don't know that?
There's nothing in the record that says that. You can presume that, but there's nothing in the record that says that. The question asked the attorney, what do you waive?
Counsel, please. He didn't go to the lawyer's office so he could have tea with him.
He
went there for a specific purpose, to take this letter, to decide whether he should sign it or not, right?
He went to the lawyer for another purpose, and while he was there, he asked the lawyer to notarize the form and say, am I giving up any rights under this? No, he did not consult the lawyer for the purpose of looking at this document.
Counsel, did he contact the attorney's office after receiving the letter to say that it was going to take a while for him to get back at the attorney because he needed to consult with counsel on this very issue?
That is the testimony of Ms. Jenkins. We have no reason to doubt that.
And that has not been disputed by your client?
That has not been disputed by the client. But I don't think his concern, as he said, was by signing this document, do I give up my right to receive the amount given in the trust document, which was $50,000.
But he was free to speak to his heart content with an attorney before he signed that waiver?
He had the opportunity to speak to a lawyer, but neither he nor the lawyer were aware of the surrounding circumstances.
So then somebody could have picked up the phone and placed a call to the attorney that sent the letter to find out what exactly the waiver entailed. Nobody did that?
Nobody did that. No, there was no particular reason for them to do that. The reasons were obviously known by Ms. Jenkins, who sent the letter, who certainly did her best to obscure the fact that they could not find the original will. I mean, it wouldn't have been difficult for her to state that.
Is that really relevant at this point in light of the fact that the original will was found? So that's not even, frankly, it's not really an issue, right?
Well, I mean, he hasn't consented to the filing of the original will either. So yeah, is that an issue? The issue is, should this fellow have the right to contest the will based on a number of substantial claims?
Okay, you'll have time on rebuttal. We're out of time. Okay?
Thank you, Your Honor.
You may proceed.
Thank you, Your Honor. Good afternoon, Your Honors. My name is Allison Arden-Basunder, and it's my privilege to represent Rosaporn Patagtum. She is the nominated executor and the respondent in this appeal. There is one issue on this appeal. The issue is, has the appellant satisfied his burden to withdraw a waiver and consent to probate that was filed with the surrogates?
So, counsel, what do you say about the letter that was sent to the plaintiff, or the petitioner here, something about court is asking you to sign this?
So I believe that the letter is very similar to the letter that comes with the New York State Bar Association Hot Docs program. I don't know for sure if it says the court asks you to do that. Either way, the letter itself said it's a copy of the will. It made full disclosure. And even if it said the court is asking you to sign it as opposed to here's a waiver for your consideration, the appellant had the opportunity to seek counsel, as Your Honors have noted. He had the opportunity to investigate, and it was incumbent on him and his attorney to ask any questions. And surely an attorney would have said the court isn't necessarily asking you, but it would be something that would save money to the court.
How long ago was it that this consent was signed?
I believe it was 3 years before 2022, so it was 2019. It was 3 years in which Mr. Richardson also came to this court in an appeal representing Mr. Iagnoko in a malpractice action against Mr. Murtha, which was dismissed. And only after or during the pendency of that malpractice action did he make a motion to withdraw the waiver. So in all that time where he says that there were red flags, it was apparent to him or to Mr. Iagnoko that if they wanted to come to the court and ask them to withdraw the waiver, they could have done it a lot earlier than 3 years when discovery had already commenced and been proceeding. So, Your Honors, it's my request that the only conclusion under law is that the surrogate court properly denied the motion and that this court should affirm. And otherwise, I'd like to rely on my brief.
Thank you.
Thank you, Your Honors.
You have 1 minute.
Okay, as to the timing, Mr. Iagnoko did file objections after the 1404 examinations revealed that among other things, that the will signing was irregular, to say the least, and we mentioned that in our brief. Prior to that time, the 1404 examinations, there'd been a proceeding under 1407 to determine what to do about the missing will. And that took over a year, and at the end of the process, suddenly the will was discovered, and that became moot. Mr. Iagnoko never consented to the filing of the original will. He did file
Counsel,
objections.
what is the good cause that you're alleging? That he had the opportunity, that he actually did speak to a lawyer, but he didn't ask the right questions? That's the good cause you're claiming should require us to set aside the will?
I'm saying he could not easily have known the circumstances.
Well, no one could. No one no one is, except a trust and estates lawyer would know, right? So again, what is the good cause? He went to a lawyer, he asked the lawyer a question, but you're saying because he didn't ask him the right questions, now we should vacate his consent to probate?
I'm saying because he was unaware of the red flags and the deficiencies concerning.
And
the
that's
size
why
of
you
the
go to a
building.
lawyer, right?
What?
That's why you go to a lawyer, correct?
He happened to be a real estate lawyer, but okay, this is, as I said, not every lawyer knows everything. And in fact, in this case, I would say with respect to the alteration of the waiver form, none of the attorneys in this case even mentioned it or noticed it until the court did. I mean, it was that discreet and that obscure in that case, which we think, as I said, is another thing which would invalidate the waiver. Thank you.
Thank you. People versus Lamik Mills. You may proceed.
Thank you. Good afternoon, Your Honors. Ashley Baxter for Appellant Lamik Mills, and may it please the court. Your Honors, the SOAR court erred in denying Mr. Mills's request for a downward departure from to risk level 1 in light of his strong family support, positive response to sex offender treatment, and substantial term of post-release supervision. First, taken together, these mitigating factors, the totality of the circumstances.
Weren't those factors already factored in by the SOAR court? So why should we downwardly depart in light of the fact that these factors that you point to have already been accounted for by the SOAR court and its RAI?
Yes, Your Honor. Well, we are arguing that these factors taken together, the totality of the circumstances, warrants that a downward departure in this case to avoid an overassessment of
I think that an assessment of the totality of circumstances here would not bode in the direction that you are seeking. Your client raped a woman, a stranger, in the hallway of her building at knife point.
And he was not assessed any additional points for using, possessing, and smuggling drugs into prison, despite the fact that he committed this crime while he was high on drugs. So he could have been a level 3, but instead, he was only found to be a level 2.
In response to that, Your Honor, Mr. Mills did complete substance abuse treatment.
You can finish your answer. Go ahead.
Thank you. Yes, Mr. Mills did complete substance abuse treatment, and he also completed sex offender treatment, which reduces his likelihood of reoffense. Your Honor, for the foregoing reasons, we ask that you downwardly depart. Thank you.
Thank you.
May it please the court, Oliver Lee for the District Attorney's Office. Your Honors, defendant committed a sexually violent offense against another resident of his own apartment building. He then disposed of the used condom in a trash chute located on his apartment floor. Further, he denied committing this offense up until a DNA analysis confirmed that his DNA and the victim's DNA matched DNA on the condom. The SOAR court didn't abuse its discretion in adjudicating defendant a level 2 and denied defendant's downward departure application, especially after also considering defendant's violent felony conviction, which was committed prior to this instant offense. Additionally, the factors identified for defendant's application don't indicate he's any less likely to reoffend. Your Honors, if there are no questions, I would rest on my brief and ask you to affirm.
Thank you.
Thank you.
You have a minute.
Yes, thank you, Your Honor. Briefly as to Mr. Mills's conviction for robbery in the second degree, prosecution states in their brief that 15 additional points could have been assessed under risk factor 9. However, it came to light at the hearing that the board didn't assess 15 additional points. The hearing court didn't assess additional points either, and the prosecution didn't ask for those points. Thank you, Your Honor.
Thank you. Walker versus Triborough Bridge.
Good afternoon, Your Honors. Miriam Manber for the appellants. The decision below should be reversed and the complaint should be dismissed for failure to state a claim due to vague and insufficient pleading. Respondent in this case is adamant that if she pleads enough details, she should be allowed to move forward to discovery. But she fails to acknowledge that, as the federal court already ruled, she needs to plead the correct details.
Different standard, though, in state and federal court in terms of what's required under notice pleadings. Don't we have a much more lenient standard under the city human rights law? And in that circumstance, why should we give collateral estoppel to the federal determination?
So there are different standards to the extent that the New York City human rights law is a more lenient standard in general than Title VII.
But isn't it specifically in terms of what notice is required? Isn't there a much more lenient standard under the city human rights law and state human rights law?
Regardless of the standard, each of them require that there be some sort of connective tissue there. There has to be something that says, I am part of this protected class, and this bad thing happened to me, and there has to be something connecting them. And so to the extent that there may be a slightly different standard, the one issue, because we're dealing with—
Slightly different standard?
It's a different standard, Your Honor.
It's a big different standard.
It is a different standard, but to the extent that we're dealing with issue preclusion and not claim preclusion, we're dealing just with, is there enough here?
What case have we ever stated on this type of matter that the federal courts declining to move forward precludes us from moving forward? What case says that?
Your Honor, we have some cases in our brief, and they're not employment discrimination cases. I believe they're equal protection cases, and there are similarities between the federal equal protection clause and the state equal protection clause.
We're not talking about that. So my question was, on these type of cases, what case have we ever said that we are precluded based on the federal court not moving forward? It doesn't exist.
There's a case called Choir versus City of New York, and we cite it in our brief. It says, because the federal court's grant of the motion to dismiss meant that the state claim was fully and fairly adjudicated in the federal action, plaintiff's claim is barred by collateral estoppel.
And how old is that case?
2022, Your Honor.
I'll take a look at it.
Thank you. But moving on.
The retaliation claim in particular?
I'm sorry?
Can you address the retaliation claim?
I can, Your Honor. And the retaliation claim has several problems. The first is that the conduct that plaintiff complains of, she complains about it before she engaged in her specific protected activity. She's saying that she didn't like the way she was being managed. She didn't like the criticism of her work. She didn't like people checking on her caseload and her schedule.
She didn't like being hit by her supervisor during an arbitration?
She did not, Your Honor, but there's no allegation that makes the connection between being hit and her.
So after she's hit, in front of an arbitrator, co-counsel, her client, etc., she is told, not only do you have to come back to work, but I'm going to move your desk closer to the person who hit you. At a time when there were only 50% of the employees at the office at any given time. So at a time when the office was 50% reduced in size, her second supervisor above decides to put her closer to her abuser. And that's not retaliation?
Your Honor, we do have a case in our brief in which moving the office closer to someone who was alleged to have been discriminatory was not held to be retaliation. But regardless, there's nothing in the complaint which states specifically, I want to move you closer to Mr. Mualem. It just says—
She was very clear that she felt discriminated against as a Black woman attorney in that office by this white male supervisor who only had criticisms for her and her other Black female counterpart. The other person under his employ, who was not Black and not white, but a male, He had the carpet treatment, the red carpet treatment for him.
At least that's the allegation.
Your
That's
Honor-
the allegation, right? I mean, those allegations, we're at a pre-answer motion to dismiss. So we assume that those allegations are true, and you're saying that those allegations aren't sufficient to allege to go forward on a city and state human rights claim?
So there are two problems with the allegations from our perspective. First is that it's a department of three. Anytime something
It's a what?
It's a department of three. Anytime something
But it's not an office of three.
In terms of who could be a similarly situated comparator, there's three lawyers. The first thing is that she didn't plead.
So you can abuse two out of the three? Is that what you're saying? I don't understand.
That's not quite
I
what
don't
I'm
understand the
saying.
logic in that statement.
What I'm saying, Your Honor, is that anytime something happens.
I mean, but that's a motion for summary judgment. We're here on a complaint and a pre-answer motion to dismiss. That's not in the record. So all we can do is look at what's alleged and say, does that at least move the complaint forward, right?
You can answer.
Okay, thank you. The one answer I would say is that to allege a comparator, you have to allege something that means that they're similarly situated under the circumstances. The circumstances here had to do with supervision and management, and there were no allegations about the work quality and how long that this person had been in the office, which I think is very relevant to, if you just showed up to the office and, an attorney is going to supervise the other attorneys very closely if you just arrived. Thank you.
Good afternoon, Your Honors. Defendants seek to apply collateral estoppel in a rigid way,
Well,
inconsistent.
let's move on from that and talk about, do you think that you have sufficiently alleged disparate treatment between your client and the other people that would compare to her?
So she alleges numerous things as the court.
Is it true that there are only 3 people in her who could be part of the comparative group?
There are 3 people who report to Mr. Muelam, one other black female and a non-black male. So we've used the non-black male as a comparator with connection of other inference of discrimination, sexist comments, a known fact in the department that he speaks demeaning to women in the department. And in terms of the mistreatment itself, besides a physical assault, there's allegations that she was scrutinized in her work. There's allegations that Mr. Mirashiro had preferential treatment with respect to even being elevated over her and given the ability to assign her work.
So let me ask you about the retaliation claim. She says that I was retaliated after I filed a complaint about the alleged physical abuse, right? And then what are you claiming, what constituted the retaliation?
So there
As
were
opposed to the original discrimination, which I'm assuming that is all the micromanaging and all the rest of that, that's part of the original discrimination, then what's new or different in the retaliation that would show that it was in retaliation for doing the protected activity?
Several things. The micromanaging changed. Ms. Gallo-Kocher, her skip level supervisor, began subjecting her to scrutiny, requiring her to complete assignments in a manner that was outside of protocol. She was, during COVID, knowing that she had an autoimmune disorder, required to come into the office to conduct virtual hearings that had not happened to her before. On the retaliation claim, it's really
Are
important.
you saying that no one else was asked to come back into the office at that time?
That's the precise reason why, at this stage, we need to have discovery. And so she.
But that's what I'm trying to figure out. You're saying that only black women were asked to come back into the office?
I'm saying that under the as evidence of the retaliation claim, that happened in close temporal proximity to her complaints, along with other things.
Right, but there has to be some connection of that to the retaliation, right?
Yeah.
All right, let's put that aside. Okay, more and different.
Are you saying that prior to the complaint, she was permitted to do these virtual hearings from home? And then after the complaint, she was required to come in to do them?
Correct, Your Honor. The complaints occurred in February, and then in May is when she was required to physically go in the office, and they were well aware that she had an autoimmune disorder. I also want to flag that there's additional evidence in front of the court about what she did in terms of protected activity that wasn't in front of the federal court, and the federal court did apply a different standard. In fact, if you look at the word because of, that word simply alone means different things under which standard is being applied. So for the appellants to see something like that that's being analyzed under a completely different standard would be crippling to the broad nature of the city and state human rights law, which seek to protect people in a manner that's broader than the federal law. If you have no further questions, I rest. Thank you.
Thank you.
Very briefly, Your Honors. The fact that Ms. Walker was asked to come in, I don't believe it's pled that she had to come in May. I think it's pled that the first time she had to come in was in November. So the temporal proximity is not quite there. And the case law...
Case law doesn't make that a fatal issue, does it?
It does not, but when we're looking at the totality of the pleading, I thought it was worth mentioning. And then the other issue I just wanted to bring up is that counsel raised the idea that it was pled that it was a known fact that Mr. Muelam had made some sexist comments to someone somewhere, and we would argue that that is not in the spirit of notice pleading. You know, that's not enough to go on if we're going to go investigate and, you know, answer that complaint.
Okay.
Thank you, Your Honors.
Thank you. All right. Compton versus Mount Sinai. You may proceed.
Good afternoon, Your Honors, and may it please the Court. My name is Kristen Gianaros for the plaintiff appellant, Mr. Brendan Compton. Summary judgment should not have been awarded here, primarily because defendants' submissions on the issue of causation were conclusory, they overlooked key facts and evidence, and they assumed facts that were not in evidence. A glaring example of this is the claim by both experts that plaintiff couldn't have had a nerve injury from this nerve block procedure because if he did, he would have had an immediate loss of neurological function in his right arm. And yet the testimony establishes that this is precisely what took place. I detail in my brief plaintiff's testimony about how he testified as soon as he woke up from the procedure in the recovery room, he felt that his arm was not connected to his body. He had no feeling over his arm or his fingers. And then 2 or 3 hours later, when the effects of the anesthesia died down, he testified in great detail to the excruciating pain he was feeling shooting down from the point of injection to his fingers, which were now involuntarily clawing in. In fact, he spoke with Dr. Edinger in the day or two after the procedure, who testified that he actually warned the plaintiff, hey, this could be a manifestation of a potential nerve injury from the nerve block procedure. So of course, there's an abundance of testimony here showing that plaintiff indeed had an immediate loss of neurological function as soon as he woke up from this procedure. Another major and significant deficiency in the defendant's neurologist report is his assumption that plaintiff couldn't have had a nerve injury here because the nerve block needle was only placed near the upper trunk of the brachial plexus nerve, not the lower trunk, which is where the damage to the nerve was sustained. But there is not a scintilla of evidence in the record to support this claim. There's no notation in the anesthesia chart. There's no notation in the hospital record. There's no notation in the operative report. And this is critical because it's this one claim by the expert that underpins the entirety of his opinion on causation. Every opinion comes back to the claim, this assumption that the insertion needle site was only at the upper trunk of the brachial plexus. And even more significantly, not only is it not corroborated by...
Am I right that all of this, at the end of the day, goes to the informed consent issue?
Yes,
correct?
this is the causation aspect of the informed consent claim. That's the claim.
So why don't, because it seems to me that the informed consent is the horse that goes before the cart of causation.
Sure.
Right? So why don't we Why don't we cover that one first?
I only address it, Your Honor, because that's the basis on which the motion court didn't touch informed consent. They touched the causation issue. But if you'd like, I'm more than happy to talk about that.
I strongly suggest you do.
Sure. The record shows that defendants never met their prima facie burden of showing informed consent was obtained from this plaintiff. The generic consent forms mention nothing about nerve injury. The doctors themselves both testified they had no recollection of treating this patient. Dr. Edinger was specifically asked, do you recall discussing the risks with this plaintiff, with this patient? And he said, I do not. And the plaintiff, for his part, testified that there was no discussion of this. He didn't even know an injection was going to be part of this.
He said that in an affidavit, but in his testimony, he said, yes, we discussed this, but I don't recall. I was more interested in the procedure itself, right?
Your Honor, respectfully, I don't think that's what he testified to. Let me just pull this testimony up. Plaintiff testified, I'm so sorry, one moment.
He testified that the doctors did discuss with him the risks of the surgery, of the anesthesia, correct?
No, he did not. He testified, I'm going to find the citation for you.
Maybe you and I read two different deposition transcripts.
Well, he testified that he said nothing was said to me that would lead me to believe that this type of thing would happen.
That's a different thing than saying nobody discussed it with me.
Well,
he admitted that the doctor discussed the risks of the surgery with him, of the anesthesia with him before the, correct? He didn't just go in and sign a form and no one said anything.
On page, in the record 584, 585, he says that Dr. Edinger explained that he would be administering the sedative, which he assumed was to calm him down, and then for sure there would be a shot. He thought the sedative was given orally, but he didn't recall and, quote, wasn't paying attention.
Well, I believe
Dr. Edinger must have mentioned to him that the shot was on his clavicle because he was putting a mark on his clavicle. He was sure they made small talk, but he could not recall. Not that he didn't. He said, I don't remember exactly, that I was focused on the surgery. His EBT read, and for me that was impactful, that he seemed, his focus pre-surgery was on the surgery itself, not the anesthesia prep. He did not seem to be overly concerned about that. In his own words, I wasn't paying attention to that. I think is really a difficult hurdle for you to overcome on this informed consent issue. And if you think I'm wrong, explain to me why that language, I didn't really care about that. I was more concerned with the surgery, why that's not fatal on this informed consent issue.
Well, Your Honor, if his testimony is, he didn't care, that doesn't absolve the defendants of their requirement, of their duty
Except that the issue for us on informed consent is there evidence that had he gotten other information, he would have done something else? And based on this testimony, that I didn't really care about that, I was focused on the surgical procedure, how can I say based on that testimony and that standard, I see nothing in that colloquy that would make me think he would change his mind.
Sure.
They put a tape on, they marked his clavicle. If I'm having surgery and they mark my clavicle and I'm not having surgery there, I mean, why are you doing that?
Well, it's not that he didn't know he was having surgery.
No, I'm saying they're marking the clavicle.
I think there's a...
That's not the site of the surgery.
No, it was the site of the nerve block, but I think there's a disconnect between being, putting a mark on you here and being advised that this has the risk of carrying serious nerve damage.
But wouldn't the fact that someone put a mark on you indicate that there was a colloquy about it, some discussion about it?
I don't think
I'm going to let somebody mark me up and not know why and say nothing.
I don't think it necessarily equates to a demonstration that the informed consent conversation actually happened. Dr. Edinger recalled nothing of the sort.
But the doctor said, it is my practice that if I am going to administer a nerve block for a procedure, I explain the risks and what we're doing in the nerve block.
Sure, it's just that there's also no notation of this specific risk of injury in the generic informed consent claims, forms.
Can I go back for 1 minute to the actual causation issue, which was what the court decided on below? Where does the plaintiff's expert specifically address the issue that the injury could not have happened the way it's described based on where the incision was? Where is the expert's rebuttal to that?
The expert's rebuttal to, I'm not.
The assertion that the injury could not have happened from the surgery based on where the incision was above versus where the injury was below. That was one of the prime contentions of defendant's expert. And where does plaintiff's expert rebut that?
Well, the plaintiff's expert points to the fact that there was an immediate loss of nerve function here.
No, I know, but it's a very specific assertion being made by the defendant's expert, and I didn't see where the plaintiff's expert said that's not true. The injury could have happened even with the insertion happening above where the injury was.
Well, I think if we can just take a step back, Your Honor.
Why don't you, what I want you to do is look through your records and see if you can find specific language to answer my sister colleague's question while we hear your adversary, okay? Because I know this is a big record and you may have something up your sleeve there.
Good afternoon, Your Honors. My name is Elliot Zucker from Aronson, Rappaport, Feinstein, and Deutsch on behalf of the respondents. Let me quickly address both the informed consent aspect and the causation aspect. Judge Manzanet, in a few minutes ago, you talked about how you have to decide is what he would have done if he was properly informed, but that's not really legally the question. The question is whether what a reasonably
person,
right, okay. And we have expert testimony about what a reasonable person would have done under these circumstances. You can read the plaintiff's expert testimony, and it's silent on the issue. By itself, that should be the end of the case. In terms of causation, while I appreciate what my adversary has pointed out in terms of what my expert supposedly relied on, my expert relied on a lot more than what she pointed out, okay?
So let's assume that your expert put up sufficient information to show that this nerve block wasn't the cause of the injury. That's the end of the case, correct? Unless the plaintiff raises an issue of fact as to that issue.
Well, that's even if you get to causation, and if you don't get past the informed consent thing, you don't even get to
Well,
causation.
I mean, what we have is a doctor who says, here's my practice, but I don't remember. And a plaintiff who says, I don't think he said anything. I don't remember, I was worried about something else. So that's a tough, for both sides, that's not quite a clean record. So let's move
But there's
causation.
but there is a difference between saying, I don't remember, and a physician saying, this is what I do.
Is there anything in the written consent form that would inform us as to what the doctor said?
No, there is not.
And the doctor says, I don't remember.
Yes, but the doctor,
Here's my practice, but I don't remember.
again, but this is not uncommon that doctors don't remember verbatim every
I can't
conversation
remember what I
they have
had
with.
for dinner last night, but I'm not on.
There's a
on
big
an
difference
informed
between
consent.
an
So
anesthesiologist saying, this is the conversation I have on every single occasion, because that's my custom and practice.
So assume that is not as clean. Let's talk again about causation.
Okay, two things I want to bring up about causation. Again, my client just wasn't relying on the things my adversary pointed out. There was testing here by subsequent physicians who came to the same conclusion.
I'm going to ask you to specifically address her argument that there's no evidence in the record that the incision was where the nerve block was where they're saying the nerve block was. What's your response to that?
Well, I think she actually contradicted herself in a way when Judge Manzanet, pointed here and she said, that's where the incision site was, the injection site was.
So where was the evidence what was the evidence in the record, though, about where the incision site was?
Well, I have to agree. There's no point in the record where it says that, it was 4 inches down and 3 across, nothing like that. This is how it's done. This is how that kind of nerve block is done. And that's what my expert and my physician say. And again, we're not just relying on that. there's subsequent testing that both her subsequent treating physicians, who also diagnosed an autoimmune disorder, and my expert relied on the EMG testing, the NCV testing, again, and that's not rebutted by plaintiff's expert at all. Which brings me to my last point, which has to do with the quality of the plaintiff's expert's proof. Okay, you have here a case where the plaintiff has dropped their med mal claims and proceeded solely on a claim of informed consent, where one of the primary issues is the cause of a neurologic injury. We have an expert anesthesiologist and an expert neurologist. They have only an anesthesiologist, and yes, while that
Yes, but he's an anesthesiologist who has attested to performing nerve blocks himself.
and who says that I am familiar with nerve injuries that come from nerve blocks. But what he doesn't say is that I have any familiarity with diagnosing autoimmune disorders, which is the thing that we say was the cause of this, and that he doesn't have, admittedly, doesn't have the knowledge to address.
We're not deciding whether or not the autoimmune disorder caused it. We have to decide that nothing the doctors did caused it. Whether or not, we're not deciding the autoimmune issue today. We're deciding whether or not the surgery did or did not cause the injuries.
Right. So you have one expert, my expert, who says that it did not, and here's in fact what happened, and the other expert who says, well, he maybe rebuts one thing, but he can't address the other thing.
But
doesn't have the knowledge.
That would be turning med mal on its head by not only do I have to establish as plaintiff what I think it is, but I have to disprove what your expert says it is?
Well, when it comes
There's
to
no case that that says that, right?
Respectfully, I disagree. I think when you're dealing with a summary judgment motion, okay, it's the obligation of an opposing expert to address each of the points that's made by the movement expert. And when the movement...
Well, he's saying there was a nerve injury caused by the surgery, that this is not the coincidental immediate onset of an autoimmune disease at the same time that he happens to have this surgery. So I think the expert is very clear about his position.
Well, that's a position that's based solely on the coincidence of timing, not on any medical knowledge.
Did any?
And I think that's different.
Counsel, did any of the treating doctors, the plaintiff's treating doctors, did any of them causally relate his condition, his complaints, his injury to the nerve block injection?
There was some initial treating doctors who listed that as a possibility, okay, and then there were later doctors, including doctors Lang and, if I could read my own handwriting, it would help. I'm not even going to, it starts with an S, who very specifically say that now, given the course of events, we can tell that this was an autoimmune response. And sometimes you can tell those things because of the chronology of how the disease progresses.
And this is in the medical records?
This is Dr. Sniag?
Thank you, yes.
Yeah, record 282.
Okay.
He said he deemed it unlikely to be due to the to a needle injury.
Exactly, and when my point about the qualification was that the plaintiff's expert is not equipped to address that because they have never dealt with autoimmune disorders at all.
Okay.
Thank you.
Your Honors, just briefly here, I think since my counsel here has
I
conceded.
still would like an answer to my question that I didn't get the answer to.
Sure. I just wanted to take a step back before we reach the plaintiff's opposition papers. The defendant.
That was my specific question. I want an
Sure.
answer. Where did plaintiff's expert address that specific issue? Because that was their major contention, that this injury could not have happened based on where the insertion was. And I don't see the response to that in plaintiff's expert response. So I want to know if plaintiff's expert did respond to that.
The plaintiff's expert, I think, sufficiently addressed that by pointing to just how implausible that could be. First of all, he had an immediate loss of neurological function, and then the post-op MRI 6 days later confirmed that he had a nerve injury to the brachial plexus nerve. This is exactly where the defendants were putting the nerve block. He wakes up all of a sudden, he has no function whatsoever in his arm, and then he's confirmed to have a nerve injury to that very anatomical structure just 6 days later. I think under these circumstances, causation is so pellucidly clear for the court here. You have a patient who woke up, who went into a surgery with full function.
Wait
and
a
woke up-
second. You're saying that you withdrew your med mal claim even though you think that causation is abundantly clear?
I do, Your Honor, because the testimony from Dr. Eisencraft is that this type of nerve injury can happen even in the absence of negligence. They're working on fine nerves here using a needle, and that this can happen. The only way to avoid this injury is just to not have the nerve block, and that's at page 771 of the record. So in terms of the injury, what was not consented to here and the causation of injuries, the link here is that plaintiff woke up without function of his arm. He never had any prior neurological dysfunction. I don't understand how under these circumstances the defendant can seriously contend and plausibly contend that the nerve block had nothing to do with the fact that he woke up without use of his arm.
Well,
Are
isn't
you
that what
saying
his
there's no negligence then?
I'm sorry?
Are you saying there's no negligence?
The claim
you're
that we
saying that
proceeded
this
on
could-
is the informed consent claim. That's the claim that issued before the court. And based on Dr. Eisencraft's testimony, this can happen even in the absence of it's just a risk of the procedure, a risk which we do not contend was communicated to the plaintiff, but a risk of the procedure.
But not all risks have to be communicated.
I'm sorry?
Not all risks have to be communicated.
Well, it should have been communicated, and I referenced the plaintiff's testimony. I'm sorry, I think I found that for you. At page, it was that plaintiff testified he couldn't recall being told that anything like this could have ever happened, which I think construing all the facts in the light most favorable to the plaintiff, the fact that there's no notation of this injury in the generic consent forms, and the fact that the doctors had no recollection, I think all of that is sufficient to show this plaintiff had no prior informed consent as to this particular type of injury. And his affidavit states clearly that, hey, this was a minor procedure for the removal of a cyst. They could have done a local block. They could have done an injection just for the hand to be numbed. I would have rejected this because this was a minor procedure. I didn't need the entire arm to be numbed. So I think that his affidavit, in any event, raises a question of fact as to whether a reasonably prudent person would have ever undergone something that carried such a severe risk of nerve injury.
Can you tell me on what page of the record the plaintiff complained immediately upon waking after surgery?
Yes.
Because I don't see a excruciating pain radiating under the arm down to his fingers until the 25th, which was 6 days later.
So in the hospital, on page 598 of the record.
598?
598 of the record, plaintiff testified. He says when he woke up from the surgery in the recovery room, I'm quoting in the middle of the page, line 14, I can't control my arm. He said gravity took it. It almost put it through a tray, and I caught it with my left hand to stabilize it. There was a nurse in the room with the expression on her face like, oh my God. He testified that he couldn't control his fingers, and then 2 or 3 hours later when he went home, the effects of the anesthesia wore off, and then he started to feel the excruciating pain. And that is more detailed around page 606 of the record. That's the same day, Your Honor. That's just 3 hours later. Page 606 confirms that.
Okay, and so are there any medical records that in his post-op chart that reflect that he was complaining of pain immediate post-operatively?
Yeah, the closest we have is when he spoke to Dr. Pruzansky the next day, and then Dr. Edinger on the 25th, he's relaying the complaints he's been having the entire time up until this point, which is neuropathic pain, significant, that's not subsiding at all. This worried Dr. Edinger, and that's what caused him to warn the plaintiff, hey, you might have a potential nerve injury from the nerve block procedure. That alone, I think, is enough to, take away all of defendant's contentions here that this had nothing to do with his subsequent nerve injuries.
Thank you.
Thank you, Your Honors.
Kushner versus Carter. You may proceed.
Good afternoon, Your Honors. My name is Mark Kushner. I am here for and as the plaintiff appellant. If it's okay with this court, I'd like to maybe refer to the plaintiff appellant here as me, or in the first person. Also, I again just want to thank the court for considering my appeal, and hopefully my submission didn't put anyone to sleep. So I'm here requesting that this court reverse the part of the lower court's order granting the defendant respondent's motion to dismiss my post-April 1st, 2020 breach of contract claims based on the finding of the lower court that the common law presumption could not apply as a matter of law because there was a downward adjustment in my monthly base compensation in January of 2020. So before the relevant period began.
Did you make any objections to that downward adjustment to your compensation at the time in January 2020?
No, not in January, but I did it in April, the end of April of 2020.
But by then, it was more than just an adjustment in your compensation. It was.
By then, all havoc broke. Yeah,
Exactly.
all havoc broke loose, right? No, but again, I mean, I didn't know what to do at the time. I mean, it was just in January, it was a total surprise that my base went down. I had no knowledge of it until it kind of happened, and I was considering what to do. And so that's what happened. Just in general, the common law presumption generally.
Can we just get some basic kind of facts down, right? When you came to the firm, you came as a special partner, right?
A partner, yes. They called me a special partner. Right?
And it was pursuant to a one-year employment contract.
It was pursuant to a contract that had a term that ended March 31st, 2018.
A one-year employment contract. And the contract specified and laid out how it could be renewed, that it would be discussed 60 days before the end of the year, correct? And twice there were attempts to have you sign another employment contract, both of which you declined.
Your Honor, you did read the briefs. Yeah, you absolutely read the briefs. Yes.
They don't believe me.
I do. I do. I'm a believer now. I now believe it.
Okay.
That's right.
So with that backdrop, explain to me how. One, based on that arrangement, do you agree that at any point at the end of a one-year term, they could choose not to re-up, correct?
They could just say goodbye. Yeah,
Okay.
I agree with that.
And if I recall correctly, it was about 60 days before any new contract, there would be discussions about whether to continue and under what terms.
It wasn't quite 60. It was actually less than 60 days. It was in March, at the end of February for one, and then in the middle of March for the other one. So
But they covered themselves the last time by doing a change of your salary with more than the 60 days before the April drop of the.
So what I'm sorry, I don't mean to interrupt.
Okay, go ahead.
Yeah. So what my position is I viewed this arrangement as an April 1st to March 31st arrangement. That's in my head. That's how I think that's how they viewed it too, per the record. So when I got that reduction, so already we're in the second renewal period, and the lower court agreed that I'd adequately alleged that.
Why isn't it clear that once they reduce the salary, why isn't it clear to everybody that that implied agreement, is not continuing anymore? Even if it did continue for the 2 years after there was no explicit agreement, but at that point, why isn't it then clear, once they reduce your salary, that the agreement is not continuing anymore?
Well, because that's not the common law presumption as articulated by the Court of Appeals in Goldman.
So then how do you distinguish Sciano versus Marina, right? The 2013 First Department case that says if you
that's your
reduce
case, right? And Holohan is your case too.
And I think it's pretty straightforward and pretty right on point.
Well, the difference,
and that means no more, that rebuts. You get the benefit of this common law presumption that doesn't exist in your contract, but you get this benefit of it, except if the conduct doesn't bear it out. And in Sciano, this court said reducing someone's salary means the presumption is rebutted. So how do you distinguish that?
Well, two things. First of all, two things. First, Sciano actually had a no oral modification clause and an integration clause. So right there, I would say that
Well, how does that affect a common law presumption? It doesn't. You're
No,
not
it
saying
does.
it's a
No,
contractual thing. You're saying it's a common law thing.
No, it does. It does, because that doesn't foreclose, because it's an intent test. And what the Court of Appeals in Goldman,
Yeah, but they showed you what their intent was. Our intent is we're not staying with this contract anymore. We are not going to continue under the terms we originally.
right, but the contract was able to be modified without a writing. So what I'm saying is that they reduced my compensation. I was okay with that. By that time, by the time April 1st rolled around, with the pandemic was happening, and I was accepting of that reduced. So it was a de facto
The only
modification.
question is whether that original employment agreement continued. Not, you weren't negotiating a new agreement. So
That's right.
you're saying you agreed to a change in terms, but you're conceding that you knew that that original agreement was no longer continuing.
I'm not conceding that at all. I'm saying that, what I'm saying is that the presumption allows me to argue that the intent, like there's a presumption here that, because this agreement was able to be modified without a writing, therefore there could have been a reduction in the salary per the agreement could have been modified, and then going forward.
Yes, but are you suggesting that in January, when they reduced your salary, that by doing that, they basically started a new contractual year?
No, they didn't. No.
Okay, good. I'm glad you said that, which then means that at March 31st, they had the option to go forward or not.
That's right, and
And they said not.
no, they didn't say not.
They said you can stay, but we're not paying a salary.
They didn't say that. They said that on April 13th, after the period began. That's when they first advised me of this. That's the point. On March 31st, they did not say that. On March 31st, the only change that was going to be carried forward was the reduced monthly payment from 25 to 20, which I would even argue is not even material. And so again, but by April 13th, that was the first time they advised me that my salary is being eliminated, my services are being changed. And by the way, there's nothing in the agreement that even talks about services. So there's no change of services, because the agreement doesn't even address kind of what, I was tax partner, so that's.
Right.
Anyway.
Got it.
All right, thank you.
All right.
Your Honors, I'm Jeffrey Boxer for the defendant respondent law firm. The issue on this appeal right now is whether the parties' February 1, 2017 contract renewed for an additional one-year period effective on April 1, 2020. We think it is clear that it did not, even if the presumption that the Court of Appeals recognized.
Outside of changing the salary number, how else did you communicate that the firm had no intention of continuing with the contract, the employment contract, even under the reduced salary?
Respectfully, we think that's a bit of a trick question, because the firm didn't believe the employment contract was still in force, that it needed to communicate that. But the court in Sciano and the Third Department in a parallel case both held that the reduction in compensation alone was enough, that there was neither of those cases referred to or required any specific communication.
So what I can't figure out is, if you thought the contract was just for 1 year, and then after the end of the year was employment at will, why didn't you cross appeal from the lower court's finding that it was a continuation?
I don't want to get too deep into what would otherwise be privileged communications with a client.
Okay.
But
So you
yes,
can't
there
argue,
were
you
cost and other factors that perhaps the $15,000.
So essentially, though, you can't argue that. You can't argue that we didn't think the contract was there. You can only argue what is this appeal.
Yes, on this appeal, I was asked a specific question about why, as a factual matter, the law firm didn't do something at a certain time, and that was the answer to why it didn't do it.
Fair enough.
So yes, on this appeal, for purposes of this issue,
Did your adversary said that he was not told until April 13th that he would not be maintained as a salaried employee any longer? Why is that true? Do you agree
It is true with a slight
statement?
modification. He was a partner, not an employee, but otherwise, The second adjustment to his
Well,
compensation was...
he's a partner with an employee contract for a year.
Well, you
You
can
know.
have a partnership agreement that has a limited period of time. But yes,
Go ahead.
as to the material part of what I think your question was, there were two adjustments that were made in the early part of 2020. The first one in January was a reduction of the base compensation by $5,000 a month, which is a 20% reduction.
Right.
The second one was communicated on or about April 13th of 2020, which was an elimination of the base compensation and a change in duties to focus on Mr. Kushner's own practice as opposed to servicing other tax needs of the firm's clients.
All right, and if in the practice of the firm over the 2 years preceding, where they basically allowed and continued the contract under the original terms for 2 additional years without there being any fanfare, right? And that the effective date of that would have been April 1st. Why is then the April 13th communication that you no longer are a salaried partner, why is that timely, and why should we not, in keeping with the holding that you had extended the contract the 2 years prior, why should that not hold here then?
Yeah, two responses to that, Your Honor. First of all, and to be direct about it, in Sciano, the first department case that is, we believe, controlling here, the adjustments to the compensation were made both before and after the expiration date of the contract, and the court in that case found both of those things to be relevant. And as particular in this case, the court below found that the January adjustment alone was sufficient. So you don't even need to go, we believe, to the April adjustment to reach the same conclusion. We think it further bolsters the decision of the court below and could be considered by this court as further, and should be considered by this court as further evidence that there was no intent to renew the contract.
Counsel,
Yes.
in Sciano, was there a integration clause in the agreement?
I don't
or a
recall right now.
modification
Mr.
clause?
Kushner says there was, and I have no reason to doubt him.
Okay, and in the other cases that were cited, Goldman and Halloran, was there an integration clause and a written modification clause in the agreements?
I believe so. Again, I don't have them all in my head at the moment. I believe so. But I would also say that, again, the question of whether there was an integration clause or not is not the relevant one when you're talking about a common law presumption about an extension of an agreement, because
Well,
that is
it would be
rebutted by the
important.
intent.
It would be important because we have to follow the contract, whatever agreement the parties entered into. Therefore, the common law presumption would not be applicable because the contract itself says that it has to be modified in writing. But you don't have that here, do you?
That is not, there's no integration clause of that type in this contract. But again, if you look at Goldman, the Court of Appeals case, while there was an integration clause, the Goldman court did not rely on that as the sole reason for the holding it reached.
That was very important to the court. That was something very important to the court because the court said there's an agreement between the parties. They bargained for that, and therefore we have to follow that because that was the intention of the parties. But we don't have that here.
I agree that the Goldman court did rely on that. It was one of a number of factors the Goldman court looked at, and I think the holding of Goldman looks to the intent of the parties. The cases that have applied Goldman since have made clear that when there is a material reduction of compensation that is intent not to continue the contract, and it doesn't continue with selected terms with other terms grafted in, it ends.
The last question I have, other than the compensation, the change in compensation, everything else remained the same. So you reduced his compensation, but he continued to be held out as to the public as the chair of the tax department, and you continue to take whatever deductions in his taxes, and he was still getting the benefits that the firm provided other employees.
For his entire tenure with the law firm, Mr. Kushner was a partner of the firm, and so he was treated just like every other partner in that way, some of whom certainly are compensated purely on a eat-what-you-kill type model, and some of whom have different arrangements. But the January change was purely to compensation. The April change was to compensation and scope of duties as well.
But the April change occurred after April 1st.
It occurred on
a few days later.
A few days
maybe
later, that's correct.
2 weeks later. That's And if the agreement was to be renewed, it would have been renewed on April 1st.
Yes, the agreement was a one-year term ending on March 31st of each year. So if it were renewed, it would be April 1st of each year. And we think the April 13th changes are relevant, both because they go to the intent of the defendant, but also because Sciano looks at both pre and post renewal date changes in compensation. Thank you.
You have 2 minutes.
First, I mean, just on Sciano, and Curran is the third department case that we're talking about here too. Those were summary judgment cases. Those were motions for summary judgments. Those were not motions to dismiss. So those were cases where the court actually analyzed the facts, all the facts, not just the one fact, this loan compensation reduction, which really wasn't, I'll tell you, it wasn't even necessarily material. That's not even a factor here, but it wasn't necessarily material because it's not just.
So counsel, let me just ask you this. Does your contract say if we don't come to any new terms, it continues for a year?
No, but it doesn't say
Nothing
it
in the
doesn't say it
contract.
expires.
Yes, I agree. So, but normally a contract expires after its term. That's a regular contract proposition. So, and yours doesn't say if we don't come. So the only thing that you are relying on is this common law presumption in employment contracts, which generally isn't applicable to anything else, right?
Correct. No, correct.
Okay.
But again,
and what the case law says is in that circumstance, if the parties manifest an intent, and one of the ways the cases have shown it is by changing compensation, then this common law presumption, which would otherwise never apply, a contract is for its term and then it's over, we all learned that in law school, is rebutted, correct?
But the question is whether that intent, first of all, what is that intent? The question is, they're relying on kind of this one fact. There are nine, I mean, I've alleged nine other facts that show a contrary intent. So again, these are summary judgment cases. Sciano's a summary judgment case, not a motion to dismiss. What this court is, what the lower court is saying is, I don't even have a case. I mean, I'm foreclosed any possibility of applying the doctrine. And yeah, okay. I mean, I guess that's again what the Court of Appeals in Goldman was looking at. They were looking at for the first time a written agreement. The presumption had been applied to oral agreements in the past, beginning in 1891, Adams v. Fitzpatrick. And what the court was looking at is kind of looking at, okay, the presumption can apply so long as it doesn't violate the written agreement's express terms. So therefore, it's potentially applicable. And then, of course, they would have the right to kind of rebut it and show intent to rebut. I just want the opportunity to present the case and to present the facts.
Thank you.
Thank you very much.
Thank you.
I'll get off the stage.
Artemao versus City of New York.
Good afternoon, Your Honors.
Good afternoon.
Stuart Finns on behalf of
Let your colleagues get up here.
Thank you, Judge.
All right. You may proceed, sir.
Thank you, Your Honors. Your Honor, I'm here on behalf of both the plaintiff appellant, and plaintiff respondent. And I'd request, Your Honor, if I could reserve my rebuttal time until after New York Presbyterian has made their argument.
Okay.
Thank you, Judge. Your Honor, the long-standing judicial precedent in this state has been that medical care falls on the proprietary side of the line. Just a little more than 10 years ago, the Applewhite Court carved out a very limited exception to that long-standing New York State principle when they found that when you're dealing with a frontline municipal EMT worker who is placing his or her life on the line to save other lives, that person's in a special situation. In addition, the Applewhite Court said that with that type of municipal EMT worker, the training that person has is limited, and the education that person has is limited. So the Applewhite Court never departed from the long-standing New York State principle that medical care is on the proprietary side. And the court balanced that and looked at that issue and carved out specific language at 21 New York 3rd at 429 and set forth the distinction, saying that when you're dealing with a medical professional that is licensed, and an EMT is not licensed, they're certified, that requires education and training that is different than a paramedic or an EMT. And also that medical doctors are in hospitals. So there's no difference, the court in essence was saying, that if you have an emergency room doctor working for health and hospitals and is giving direction to a staff member at the hospital, there's no different than a medical doctor who is a telemetry doctor giving direction to somebody at a scene. Now, that telemetry doctor is in the protection and confines of an office environment, not on the front line, has extraordinarily high education, went to medical school, did a residency, did a fellowship, worked in hospitals. There is a clear line distinction that the Applewhite court has addressed. And they did that for the very important policy decision. But in addition to that, Your Honors, here...
What about the fact that in this case, she had a very limited function? It's not like when you go to a doctor and you go to the hospital and you're getting direct medical treatment from that doctor. Her only role was to be part of this 911 response system, to answer the call from paramedics, and to be a very specific link in the chain. So why wouldn't that case control in this, in terms of it not being proprietary under those circumstances?
Thank you, Judge, for that question. Your Honor, here, what the city did was they displaced the function of a proprietary function, and they're trying to make that into a governmental function. But here, there was not such a limited role. This was a medical doctor who gave authority to prescribe a very, very powerful drug, the sedative Versed. That's not a limited role. When you are prescribing a drug to somebody who just went through a seizure and is in the post-ictal state, in addition to that, when that doctor is armed with the knowledge given to it from the telemetry private medic, and that's a private medic that was not a city medic, that this paramedic is now sitting on Mr. Artemao.
The sitting on is a different issue, and we'll talk about that when we talk about the paramedics, which you didn't want to talk about now. But now we're just talking about the role she played. She had no ability to give direct medical treatment to the plaintiff in this case, did she? Her only role and her only function was to answer questions of paramedics. Isn't that correct?
Of course she wasn't.
Why isn't she part of that system, which is part of the non-proprietary?
She was acting in the same capacity as a doctor calling into the emergency room at health and hospitals. She had the function of medical care, the high level of education, the very things that Applewhite distinguished when they said, when we're dealing with medical care from doctors and prescribing a powerful sedative, that's medical care. That's something that significantly is affecting the human body. That's care. And she's not a frontliner. She's in the same situation as any doctor in an emergency room. And the danger here, a very slippery slope. If
the doctor in the emergency room would be actually talking to the patient, speaking to the patient, evaluating the patient in person, as opposed to her role, which is just to communicate with the paramedics.
Not always, Your Honor. Not always. There's many times where a doctor will review a chart.
Counsel, I really suggest that you move on to your next issue.
Thank you, Judge.
You're running out. You have a minute left, and you haven't touched any other issue.
Thank you, Judge. I'm going to move on to the New York Presbyterian situation. There, Your Honor, the trial court was correct in denying summary judgment for the following reasons. There are tremendous issues of fact which must be reconciled by a jury, and that's what the court below found. And let me just bring a couple of them to Your Honor's attention, please. The timing of Versed. When was Versed given? There's a dispute in the record as to whether or not it was given right after the paramedics arrived and their private paramedics, or was it given after the telemetry call where there was authorization to prescribe that? In addition to that, did Kremenizer, the paramedic, restrain by sitting on Artemao? We say yes, and of course the defense says no, there was no restraint. However, the testimony of Kremenizer is that although he defines sitting on by restraining, using his right leg on his back, his left leg was on his chest. He was compressing a 350-pound man, restricting his movement, not letting him roll onto his stomach, because Artemao wanted to get onto his stomach, use his hands, and stand up, and he was just restraining him. Another question: did the restriction by Artemao, by Kremenizer, restrict Artemao's breathing? We have affidavits that are conflicting. However, when you have a post-ictal person and you have somebody who now is being restrained and also was administered Versed, a respiratory suppressant, and then right as they're being restrained, they go into respiratory and then pulmonary arrest. Our expert goes into that in detail. The defendant's expert has a completely different theory. And there's another question there as to the timing of hypoxia. When did Mr. Artemao become hypoxic? We say he became hypoxic after he was trapped by Kremenizer, and all of these gases built up. He was not able to bring in enough oxygen because his diaphragm could not go down far enough. He was not able to expel carbon dioxide, so that he became hypoxic, and that put him into respiratory and cardiac arrest. The defense says to the contrary in their expert, without much foundation at all, that the hypoxia was caused before the paramedics got there. Now, factually, Your Honors, and the affidavit set this forth, if you are so hypoxic because of the buildup of carbon dioxide, you're not going to be able to stand up, stumble around, and then fall down and stand up. In addition to that, the defendant expert sets forth in his affidavit, which is completely unsupported, that there was prolonged seizures that created built-up lactic acid. And the lactic acid is what produced the respiratory and cardiac arrest. There's no support for that because these seizures were unwitnessed. And the paramedics' testimony was, we didn't get there. When we got there, there was no seizure activity. He was just standing up, and he would fall right down to the ground, and he would stand up again, and he'd fall right down to the ground until the paramedic grabbed him by the back of his belt, and he put him up against the wall, and he brought him down to the ground, and then he straddled him like a tripod, and he compressed him. And that's what caused his respiratory arrest. So we have competing experts at the very worst situation.
Can I ask you, what is the evidence that you're submitting for that they compressed his airway? What evidence do you have of that?
We have experts that set forth that when you have this condition...
Did anyone see that at the time, the medical records at the time?
The only one in the... I'm sorry, Your Honor.
The only thing that I see says that didn't happen, and your experts 2 years later said that happened based on what?
That is the medical causation. Now, the only one in the room, and of course, Mr. Artemao was no longer here, so I would hope that he enjoys a lesser burden on that as well, but the only one in the room was paramedic Kremenizer.
Right. Again, I'm asking you, what evidence have you submitted? What do your experts rely on, I suppose, is what I'm asking you.
They're relying on the mechanism of the injury. And number one, Judge, that what the defense says in their affidavit, you physically can't stand up. If you are so hypoxic, and that's brain damage, you cannot physically stand up, walk around, fall down, and stand up again. It's impossible. You can't do that. So the evidence is that he was standing up, he was walking around, he was okay when the paramedics first arrived. He was then restrained, and he was restrained for 11 minutes. There was 11 minutes unaccounted for in the PCR where the paramedics arrived at 8:38 in the morning, and he went into cardiac arrest at 8:50. There was nothing in the PCR as to what happened. And the testimony, of course, by Mr. Artemao, you can't, but Your Honors, if you do want to hear something from the telemetry tape, there is a call out from Mr. Artemao just seconds before he went into respiratory arrest. And I think Your Honors probably know what those words are. There were 3 words, and it's a tragic situation that when he was being compressed, he went into respiratory and cardiac arrest. And our experts go into great detail as to the mechanism of what produced that. how he went into cardiac, first pulmonary arrest and then cardiac arrest.
Thank you. You'll have time on rebuttal.
Thank you very much, Your Honors. I appreciate your time and your courtesies.
You're welcome. I don't get that often. Thank you. You may proceed.
Good afternoon, Your Honors. May it please the Court. Richard Wolf of Martin, Clearwater & Bell, LLP, for Defendant Appellant, New York and Presbyterian Hospital. Your Honors, to address one of the points made by my adversary first, and to Your Honor's point, there is no evidence in the record that paramedic Kremenizer was compressing.
I think his EBT is evidence.
I disagree, Your Honor.
Counsel, he can't have it both ways, because he testified that he needed to administer Versed because Mr. Artemao was so out of control that he was concerned that he would hurt himself or that the patient would hurt himself or others, meaning him and his fellow EMT. So if he was so out of control that he needed to sit on him, and those were his words, nobody else, his words, that he had to sit on him in order to control him, right? And he pointed out that the gentleman was obese, a big man. So if you straddle a 350-pound man who is physically not in control, something is happening to him that has him out of control, then you would be toppled over if you don't press in order to hold him still. So it just defies all logic to say, I straddled him just to be over him. No, he straddled him because he felt he needed to control him. He needed to stop his body from flailing about so that he could try to administer aid. So he can't have it both ways.
Your Honor, I think his testimony is clear that he did have both legs on either side of the patient who was laying on his side, and he was positioned in a way so as to restrict his movement from spinning over, essentially, onto his front. However, that does not mean that he was compressing the lungs or the diaphragm of the patient. He had...
So now that he's on his side and straddled him, now the patient has become calm and he's no longer flailing about? That makes no sense because they still administered the Versed.
Correct, Your Honor.
Right? So obviously, he was still out of control.
Your Honor, from the testimony in the record, the patient was trying to spin, was trying to move. However, that does not mean he was compressing. He was the patient.
So then I'm going to ask you that, because what is the evidence? What was the expert evidence that anybody compressed as opposed to restrained him, put it there? What evidence does the plaintiff's experts assert supports compression as opposed to right? Of this,
Correct,
as
Your Honor.
opposed to keeping him still.
No, the diaphragm is down here.
Right, I'm sorry, here.
Right?
Here.
So if he's got his body by his stomach and on his back, again, he's 350 pounds, gotta be at least this thick, right? So he's just standing and that body is staying still now. Yet I still administer Versed.
Your Honor.
Also, those things just don't go together. There's common sense.
Yes, Your Honor, but as the patient is spinning, trying to attempt to move, to spin, he's hitting the paramedic's leg. That does not mean, and to Your Honor's point, there is no record in the evidence, and the plaintiff's experts cannot point to anything. They purely speculate that the paramedic is squeezing or compressing his legs into the patient.
What should I read into the fact that his fellow EMT, in the middle of this incredibly difficult patient to manage, leaves the room for 5 minutes to make a radio call, just at the time that the EMT says, I'm sitting on him. No, I don't mean sitting on him. I mean just straddling him. And, oh, I wasn't applying any pressure because I didn't need to do that.
Your Honor, I believe the record is clear.
How convenient that his coworker is not present at the most urgent moment of the call. How does he leave him alone when this man is out of control?
Your Honor, it's that very urgency that required paramedic Strong to leave the room. He needed to call dispatch for additional assistance, and he could not get through on the radio in this older building where there was not much windows in order to have better service.
But if additional assistance is needed, why leave criminalizer alone with a person that is out of control? So that statement, I'm sorry to say, doesn't make any logical sense. Because if you're saying that they need additional assistance, so you're going to respond by leaving him alone with one person when maybe two can possibly put him under control?
Well, Your Honor, to plaintiff's expert's point, that would not be the satisfactory thing to them because they say that they shouldn't have engaged at all, which is also without any record in support in the record because they rely on New York City paramedic guidelines, which were not attached to their expert's affidavit and were not included in the record. But the paramedic Strong needed to leave, I think exactly for that point, to obtain additional assistance because the patient was out of control, and nothing would have improved the situation until additional paramedics could arrive to assist in the situation. If I may briefly turn to, or address quickly the sitting on, I think the record is clear that from the testimony of paramedic Strong, Creminizer.
Strong didn't see, so don't say Strong, because Strong said he wasn't there.
He wasn't there for a part of it, that is correct.
He said, I saw nobody sitting on nobody, I wasn't there. That's what he said. So Strong, let's take him out. The only one who can testify about it is the EMT, I can't pronounce it, Creminizer.
I disagree, Your Honor, because also none of the patient's coworkers saw anyone sitting.
They were not there. They left the room before the sitting occurred.
Well, the evidence in the record, I believe, Your Honor, is that the coworkers were asked to leave the room when the second EMT crew arrived, which, as paramedic Creminizer testified to, they didn't arrive until the end of his call with telemetry. And I'll save my other arguments for rebuttal.
I'll give you another minute. We badgered you with questions, so if you have a couple of points you need, I want to be fair. Go
Okay,
ahead.
to briefly address the sitting on, also the telemetry, both telemetry physicians did not understand that to mean that he was literally sitting on the patient. Creminizer and Dr. Silverman, I believe, not Dr. Schweitzer, the other telemetry physician.
I mean, they seriously twisted themselves into pretzels coming up with explanations for the common word, I sat on somebody.
I mean,
Okay? You said, I'm sitting on the scene. He said, I literally had to sit on him.
He said, we're sitting on the patient, but that is a common phrase in the paramedic field, as both paramedic Creminizer and Dr. Silverman testified to, has a common meaning that does not mean literally and physically sitting on.
In the 12 years I've been in this court, I haven't seen one transcript with an EMT saying, I'm sitting on him. Not once.
If you prefer I save for rebuttal, or if I may have one more minute to address the argument.
I'll save the rest for rebuttal.
Okay, thank you, Your Honor.
Good afternoon, Your Honors. John Shep Wong on behalf of the city. I think that I submit that the issue with regard to the city is a bit simpler because this is all about governmental function on the city's part. Providing emergency medical services is a governmental function, and that is undisputed in this case. So the only issue is whether telemetry is part of that emergency response system. And I would disagree with my colleague in terms of what Applewhite actually says. The Court of Appeals states explicitly, we hold that a municipal emergency response system should be viewed as a classic governmental function. It's not talking about just an exception to medical care, it's talking about the emergency response system as a whole. And I submit, when you look at what telemetry physicians actually do, it's clear that they are part of that system, part and parcel. They aren't practicing hospital medicine. They aren't treating patients. What they are doing is taking phone calls from paramedics and EMTs at the scene, applying written protocols to the scene as it's being reported to them, and then in that way helping get people to the hospital as quickly and as safely as possible. That they do this by phone and that they're not on scene doesn't change that. 911 operators do their jobs by phone. They're still part of the emergency response system. They're still performing a governmental function. Others, denying a building permit or a certificate of occupancy. Court of Appeals says that's a governmental function, but that's not on scene. That's not placing your life in peril, nothing like that. So that's not actually a factor in this case. And I would submit that the fact that that telemetry is off scene, that all they can do is respond to what the paramedics are telling them, that actually supports our position that this is a governmental function, that this is a narrow, limited role that these physicians are playing, not acting as treating physicians. On the medical training point, the fact that they have a degree doesn't remove them from this response system, because everything that they do has to be done through these paramedics, through these EMTs, because they are, again, not on scene. So all they are doing is helping paramedics perform their jobs better, and that is governmental and not proprietary under Appellate. Hopefully.
Hopefully better.
That's the idea, Your Honor. So I think it's important.
I certainly have had these cases before, and I understand the concept. I suppose as a New York City citizen and resident of this state, I think what concerns me is that the public has no idea what ambulance comes to help them, has no idea whether this is run by the city or not, and whether the advice given by someone on a phone call and has my life on the line, they can make an absolute huge mistake, and I have no recourse then against that particular entity, simply on the basis of that, whereas if it were a private ambulance, I would.
In many circumstances, that's true, Your Honor. I think that...
And we have no choice. We don't, it's not like I can, 911, don't send me a city ambulance, right? I can't do that. I just, it's the luck of the draw. So it's unfortunate. That's all.
Thank you, Your Honor. There are other avenues that the plaintiff didn't even allege here, special duty, and that sort of circumstance that would impute liability to the city. But in this case, that's not even in this record.
There's no facts here that would support a special duty anyway. But I thank you.
Thank you, Your Honor. I would rest on my brief with regard to the other issues.
Thank you so much. Okay, you're up first, as he requested. And you didn't object, so there we go. I'm gonna give you 2 minutes.
Thank you, Your Honor. To briefly address some of the last points, contrary to what my adversary stated before, it's not our contention, and wasn't our expert's contention, that the hypoxia was caused before the paramedics arrived. The position that, and the opinion of our expert, Dr. Kwiatkowski, is that due to the contractions during the seizure and the postictal state, which continued through the paramedics' arrival and first interaction with the patient, metabolic and respiratory acidosis was occurring and progressing throughout the entirety of their interactions with the patient, to the point where he finally reached cardiac arrest. Second, with respect to plaintiff's experts, many of their opinions are based on allegations which are not included in the complaint and bill of particulars. I went through, and I'm not going to belabor the point in my brief, all of the different words that were never even included in the complaint or the bill of particulars, addressing compression of the diaphragm, addressing the alleged failure to secure an airway, the allegations with respect to waiting for NYPD or other police to arrive to assist. None of those allegations were ever in the complaint or bill of particulars, and therefore should not have been permitted to be a basis upon which plaintiff could oppose our meritorious motion for summary judgment.
You're not suggesting that an expert's affidavit has to model itself after the complaint, do you? That they have to use the exact same words?
Not the exact same words, Your Honor, but the allegations.
I mean, that's
that are
why they're
addressing here-
experts and we're lawyers. We say it in a lawyerly way and then they elaborate and expound on whatever theories put forth, no?
Right, but the theories that were set forth in the Bill of Particulars here are vague to the point of meaningless. The allegations that the opinions that were being offered by
But counsel, that's what you take a deposition, right? And on the deposition, the paramedics and the were asked all of these questions that are now part of the complaint, right?
That is correct. Some of these things were asked at the deposition. I don't believe that anything with the NYPD or waiting for police was. I could be wrong,
but whether or not he sat on him, whether or not he compressed his airway, whether or not they continuously monitored him, those were all explored at the deposition, right?
They were, Your Honor.
I can't say I had no idea that this was going to be coming up.
I would just submit, Your Honor, in this situation where paramedic Kremenizer's deposition was completed over a year before the note of issue was filed. Plaintiff had plenty of time to amend their Bill of Particulars, and I would submit that they should have done so.
There's no requirement to do that.
It's a rough and tumble world out there.
Thank you.
Thank you for your consideration, Your Honors.
Thank you, Your Honors. Your Honors, as Your Honor raised, it was covered in the Bill of Particulars, and just saying one of the lines of the Bill of Particulars.
No, I just want to ask you again, what evidence did your experts rely on with respect to the fact that they compressed the compression was what caused the problem here?
The evidence that was relied upon, Your Honor, was the deposition of Kremenizer. That's one part of.
Well, he says he didn't do it, so they couldn't have.
Your Honor, with all due respect, he said that he was restricting, and it was his words, not mine, restricting his side-to-side movement. And as your colleague, Your Honor, had mentioned, when you have a 350-pound man between your legs, and by the way, Kremenizer himself was 220 pounds, 511, 5 feet 11 inches tall, and a former
511 feet tall would have been really tall.
But he was also a former Israeli military soldier. So he knew what he was doing, and he was restricting his movement side to side, and that's what his testimony is. That's number one. And number two, Judge, you asked the question on causation. Let me just bring one other point. After Peter Artemao was in cardiac arrest for several minutes, they used an intubation tube with a device on top which would determine what your carbon dioxide level was, the end tidal of carbon dioxide. It came up as 75. And the mechanism which our expert went into, the mechanism of that which supports causation, is when Peter Artemao was between Kremenizer's legs, this is a slow process of the inability to breathe. You start taking in less oxygen, expelling less carbon dioxide, and it's a process, and he was between his legs for 11 minutes, and that's unaccounted for in there, but we know that he was there for a long period of time. That's a long process where you start to become hypoxic. And now he goes into pulmonary and cardiac arrest, and it takes them a while to resuscitate him, 20 minutes before they can resuscitate him, but they put an endotracheal tube in, and even though his heart's not beating, when they finally, get some air in and they get some carbon dioxide out, it's a high level, it's 75 of carbon dioxide. That is further proof, and set forth by our expert in the expert affidavits, that the long process of being held between the legs of Kremenizer was a proximate cause. Doesn't have to be the only cause, Your Honor, to what happened. And maybe there was a combination of causes.
So you're talking about the failure to monitor that?
Not failure to monitor, Judge. No, that is a level at the top of this tube. You stick it in at the top, there's a little meter. And the meter will tell you how much carbon dioxide is coming out of you.
So you're not saying that they failed to monitor his breathing appropriate?
Of course, Judge. Yes, during this process, they should have been monitoring his breathing. It's the ABCs. It's airway, A, B, breathing, C, circulation. Those are the three fundamentals of any EMT or paramedic or telemetry doctor, and that was not done.
Thank you.
So much, Your Honors. Once again, appreciate your time.
Sickenger versus Sickenger. You may proceed.
Good afternoon, Your Honors. Heidi Talentire for the defendant appellant. May it please the court. Your Honors, this is about a little girl. She's 6.5 years old. She needs your protection. She's in danger from her father. She has already...
Counsel, you are not in trial. You're arguing an appeal.
I understand,
Okay?
Your Honor.
Please.
The facts are undisputed, Your Honor.
Counsel, there was an extensive hearing before Justice Katz. He heard all the testimony, he heard all the witnesses, and he made a determination based on his credibility assessment after hearing everything. Why should we disturb that?
Because, Your Honor, he gave no weight to the uncontroverted expert testimony, which stated that this child has already been harmed by the father. She is in continued danger from the father.
Let me ask you that, because there was a very restrictive supervised visitation order put in place in this case, which is somewhat unusual. And that was in place, and it continues to be in place, and there was a grandmother who was a supervisor. What was different by the time this subsequent application came that wasn't already present when the first application was decided and this restrictive procedure was put in place?
So at the time, there was no knowledge that the father was lowering the boundaries and the inhibitions of this child by, whether you want to call it grooming, or by using such language as he's admitted to as, did you dream about me just a little?
So
That's
what about
awesome.
the fact that the current parenting coordinator did not recommend any change in the circumstances of what was set up?
So if you're referring to Dr. Bierman is the one who first raised the issue of being concerned that the father is grooming the child to be his girlfriend. That is also set forth in Exhibit 6 of the record.
Recommendation that there shouldn't be any change in the current circumstances, which only allow him to be with the child being supervised.
Correct, Your Honor. She recommended that he have unsupervised morning visits, which then the court, when hearing about this, changed to fully supervised. Once this court determined that the father is credible in saying, okay, I won't do it again. Yes, I did it. I didn't know I shouldn't say these things. I'm not going to do it again. Even though Dr. Weiss, the court-appointed expert, stated unequivocally that that is not sufficient, that it is a facade, that he does not fully understand what he is doing, and this is something that is behavior that will and likely will continue. Despite that, the court said, okay, I'm going to accept what the father said, which means that now we have a new parenting coordinator who has now lifted some of the supervision. The father is now unsupervised on weekends for 4 hours, plus he has an unsupervised dinner. The father is continuing to push for more unsupervised visitation. As the court saw in the record, if the current order stands, which is the separation agreement that was entered into prior to any of this knowledge about the potential grooming, if that stands, the father will be fully unsupervised in approximately 2 years. And he is pushing for full-day unsupervised visitation right now. So you have a little girl who's being asked by the court and by the parenting coordinator to be the one to reject the improper behavior by her father. You're being asked, you're asking this little girl to determine whether or not she's 6.5 years old. She was 4.5 when her dad said these things. He didn't talk to her about going to the zoo. He didn't talk to her about going to the museum. He talked about whether or not she remembered their feet touching under the table. So we're asking a little girl to know whether or not she has to say, oh no, Dad, that's not appropriate. We can't talk about that. We're asking a little girl who should have a robust and real relationship with her father to be the one to reject unacceptable behavior. And
So
Dr.
wait,
Weiss
so counsel,
testified.
you're not disputing that the parent coordinator that is here now is in favor of the schedule that Judge Katz awarded, correct?
So, Your Honor, I am disputing that because what my understanding of what the parenting coordinator has stated is that he has said he has to ignore everything that Dr. Weiss said and everything that Dr. Bierman said.
No.
Therefore,
The question is the parent coordinator right now objecting to the schedule.
No, he has expanded the unsupervised time.
And let me just ask you one more question. And Dr. Weiss was cross-examined, correct? And there were a number of things that Dr. Weiss didn't do that the court noted, correct? She didn't talk to the grandmother, and there were other things. There was a question of whether Dr. Bierman refused to sign an affidavit that the mother put before Dr. Bierman, correct?
So with respect to Dr. Bierman refusing to sign an affidavit, yes.
Okay,
With
and what
respect
about the
to
doctor?
speaking to the grandmother, that is not correct, because there was an initial interview with, because remember, this was the second forensic evaluation done by
Yes,
Dr.
but for
Weiss.
this evaluation,
For this
the grandmother was not spoken to.
She relied on the affidavit that was put in support of the father's response to the order to show cause from the mother, in which she said that this behavior by the father was normal, acceptable, and she saw no issues with it. And so now we have a situation where he's not even supervised by grandma during part of the time, and he's moving for even further lack of supervision.
You have time on rebuttal.
Thank you.
Good afternoon. Andrew Sickenger. I'm a pro se litigant in this matter. As the court accurately articulated, this was a very, very long trial. There was a lot of evidence and a lot of testimony that was put forward. Judge Katz, in his decision, cited the extensiveness of the information that he reviewed, which did include the Dr. Weiss report.
How do you respond to counsel's statement that you have no insight on what is proper and improper with a young female child, your child?
That is opposing counsel's point of view. That is an incorrect assessment of what Dr. Weiss observed in the second report. You'll note that she had 2 observations with me and our daughter, and both were appropriate, child-friendly, just completely suitable interactions.
Sir, you admitted that you engaged in some of the conduct that your ex-wife found objectionable, correct?
I fully admit those items were said.
All right, and so my question to you is, do you now have insight why it bothers everybody that you refer to your daughter as your girlfriend? Do you have insight on that?
I never referred to my daughter as my girlfriend.
Okay.
Absolutely, unequivocally, that has never occurred. In fact, the report goes on to say that there is no evidence that I have any interest in younger women, and that would never be.
But there were some things that you admitted to doing, touching her feet, asking you if she dreamed about you, things like that, that made your ex-wife uncomfortable. So the question I think my colleague is asking you now is, do you have insight into that and
yes, of course.
Why that was uncomfortable and not repeating that behavior?
In October of 2020, these items were brought to light. In the 9 months that followed that, there was this extensive Dr. Weiss report that was put forward. Once these allegations were brought to light in October of 2020, every single one of them stopped. I do not argue that they didn't occur. I will argue that the intent behind them was pure and loving.
There was no malintent.
There was no malintent, but nonetheless, I stopped those entirely. And there was no evidence in the Dr. Weiss report, nor at the trial, that there were any new instances or repeat instances that raised any concerns. Thank you.
You have 1 minute.
The only way we would have any new evidence is from the child. Additionally, the respondents claim that because...
Wait, are you saying that there aren't any more Zoom calls and stuff like that?
Correct. My client, the reason these allegations even came to light, they're not even allegations, they're facts because they're admitted to. The reason these facts came to light is because COVID happened, and my client became the supervisor, and she's watching these FaceTimes.
I'm just asking whether there are no more Zoom calls, no more...
There are no Zoom calls in which Mr. Sickenger, the respondent, is having communication with his child that would then be supervised by my client.
But are they supervised by anyone?
Well, during his supervised time, obviously he's being
So your
supervised
child's
either by
not
the
the
mother
only
or the
one. Your child's not the only one who could report, right? There are supervisors who could
Correct.
support. So that's an incorrect statement, right?
So, yes, if you assume that the mother would report what, the grandmother would report what her child was doing, and Dr. Weiss did not believe that to be the case and went into extensive testimony about that.
Okay, thank you.
Thank you.
People versus Christopher Salas. You may proceed.
May it please the court, Benjamin Brindis, appearing pro bono in conjunction with the Office of the Appellate Defender for Appellant Christopher Salas. This case should have been about the prosecution's extremely weak identification evidence. Instead, due to counsel's multiple grave errors, the prosecution was able to introduce 2 additional identifications through the testimony of Gregorio Urena. These 2 additional identifications doomed Christopher's misidentification defense, the only defense he raised, to failure.
These were people who knew each other, though. I mean, they didn't know each other for a long time, but they weren't complete strangers to each other. They had played baseball together.
No, Your Honor. On the contrary, Urena testified to a bare acquaintanceship. He said that they met maybe 2 or 3 times. And because
Well, how many times do you have to meet someone before you know their face?
Because counsel waived an already ordered Wade Rodriguez hearing, he never had the opportunity to explore that relationship outside of the presence of the jury. And I will say, in front of the jury, he was not able to ask, were they on the same team? What, was one person playing catch or one in the outfield? The fact of the matter is he didn't have that opportunity to cross-examine Urena and build a record, a colorable record for suppression of Urena's identification in court as tainted by the single photo.
He didn't cross-examine him in court?
In front of the jury, Your Honor, but
He did,
Rodriguez...
right? Didn't he? Didn't cross-examine him pretty extensively about whether or not he identified the right person?
Your Honor, Rodriguez makes clear...
I'm just asking you, yes, but first let me just ask you, he did cross-examine him about his identification, correct?
Yes, there was some cross-examination about...
And there were 2 other witnesses who also identified the defendant.
Those 2 witnesses were identifying him for the first time at trial, almost 4 years after the incident. They had never previously met Christopher. They were both close friends of the deceased, Mr. Perdomo. Urena's...
And all of that was in front of the jury. The jury heard all of this, and they assessed, they weighed all of that and still found the defendant guilty.
But Your Honor, you have to recognize that Urena's 2 identifications quantitatively doubled the evidence of identification before the jury, where there were these 2 weak identifications, all of a sudden there are 4. I'd also like to emphasize that the jury was skeptical of at least Gallardo's identification, and jury note 1, they request Gallardo's testimony and a statement that he made to the DA, in which he provides no nickname, no name of the assailant, doesn't provide basic identification information, the height, the weight, the age of the assailant. The jury were skeptical, and this court should recognize that Urena's 2 identifications were particularly damaging, and they shouldn't have come in. He was the only witness to identify having testified to at least some prior encounter with Christopher. Because of counsel's misrepresentation to the jury...
There's no requirement that an identifying witness have a prior encounter with an assailant.
No.
1. So the fact that they had not previously identified him is immaterial.
No, Your Honor, but it certainly speaks to the relative strength of Urena's identification. That wouldn't have come in, I'll add, that if counsel had not misrepresented facts to the jury. While the prosecution at trial initially said they would cure that misrepresentation through the testimony of Detective Greery, immediately before Urena testified, they made an application to the court to ask Urena about...
Familiar.
Yes, and refers back to them opening the door. I'd like to emphasize as well, there's no basis in the record to believe that there wasn't a colorable reason to hold the Wade Rodriguez hearing when it was waived by the trial counsel on April 25th. It was ordered by...
I understand. So for us, the issue is whether that error was so great as to constitute ineffective assistance of counsel and such that it would have changed the outcome of this case. So we don't look at just this one item in a box, right? We look at the whole picture, and this is but one factor.
Your Honor, in Jones, this court recognized that even a single prejudicial error would be sufficient for ineffective assistance under this.
And if I suggest to you that this one is not sufficient to turn around in a conviction, what else do you have?
Well, I just emphasize there's multiple errors here. He was completely unprepared for trial. He engaged in questioning that he admitted on the record he would not have done if he had known what was in his file. If this court
That he would not have done if he knew what?
if he had seen Urena's signed identification photo. The prosecution turned over in discovery a signed identification photo. Counsel never saw that before he cross-examined the most critical identification witness at trial. He was not familiar with the facts in the procedural history of the case. And I'll address Christopher's third point on brief, if I may, during my rebuttal time.
All right.
Thank you, Your Honor.
Good afternoon, and may it please the court. Paul Anderson for the people. To clarify the record, there was nothing that counsel did or didn't do that would have stopped Urena from testifying. At voir dire, the prosecutor
Counsel,
said,
that's not the issue, and you know it. The defendant has a right to not testify. That doesn't mean his lawyer should sandbag him with bad,
saying Urena, the witness.
Oh, the Urena. I thought you meant the defendant.
No, no. Oh, gosh, no.
No, the witness.
Definitely not that.
Forget it. I'm sorry.
No, but Mr. Salas did not testify. But in terms of the witness at issue here, he was unavailable at voir dire, and then 5 days later, we made a record to the court. We found him, and he had relevant evidence in front of the court. There was no door opening to get this eyewitness who knew Mr. Salas in to testify. And as Your Honors were just noted, the Rodriguez-Wade issue, it was satisfied that there's no non-strategic reason, and everyone had enough to make the independent source ID. To move on to, I think, the Orama issue, which I think really should be addressed first. This is, I think counsel would also agree, a very novel application or a novel wrinkle to Orama in terms of what is the record we have, and did we have enough to say that the duty under 31030 is triggered here? I think what we're at odds is counsel says that we can't affirm without a reconstruction hearing. I believe we can't
But I mean,
reverse.
that wasn't really denied, right? It was denied with leave to renew.
It was denied with leave to renew, yes, Your Honor.
So
we have nothing here.
there's nothing for us to, they can renew that, the defendant can renew that, right?
Yes, today I provided Your Honors with People v. Myers, which I think has a similar issue in terms of if there's a question of what the jury note, how it actually ended up in the court file, which I believe the record here is very unclear.
It's not how the jury note ended up in the court file that's material. It's how the jury note was dealt with.
Well, and so for People v. Meyer, that was a case where the defense counsel on appeal discovered this note. It had like some hallmarks of maybe it was part of it, but there was no idea. There's less record evidence than we have here and when we don't have the transcripts at all. So like if you look at the note itself, note 1 has notations, court exhibit number. Note 2, the note at issue, has nothing in the bottom. And then note 3 has notations on it. So we do not know if this was actually a note given to the court to actually trigger the duty of whether material.
So I mean, but wasn't that the reason why the motion was denied with leave to renew, for the defendant to try to do what he could to reconstruct through subpoenaing other records?
Yes, Your Honor, and the fact of the matter.
So I mean, it's not a denial with prejudice. It's a denial. Try again and try some other things first, right?
Yes, Your Honor. And so.
Why don't you address the fact that the defendant was 16 at the time, and it's his first offense, and he gets 22 years, and if he was convicted today, he could not even come close to that.
Well, I think if we have to look at what the sentence was at the court at the time, and I recognize this court has independent review power, but this is a 16-year-old defendant who armed himself with a knife on the street, engaged with someone saying, I'm going to confront someone about this issue, confront someone in one of the most violent ways in which someone had to throw a bicycle for him to stop, and then never had any of the...
But I mean, if all those facts were true today, he wouldn't be eligible for 22 years, right?
Yes, Your Honor, but I think that's then now, it's a quasi question for the legislature for.
And the legislature
also for
has
you.
spoken, right? The legislature has spoken very loudly.
But for a look back?
16-year-olds do not have the same brain capacity and judgment-making capacity as a grown adult. They just don't. And I've never seen a fact pattern that exhibited that better than this one. This young man was about to walk away. And then, ironies of all ironies, stupid, goofy, whoever he was, tells him, no, that's the guy who was threatening your mother, and he loses his mind and stabs this other person to death.
Stabs him to death, drags him across.
If there is a case that exemplifies the lack of judgment of a 16-year-old, it's this case. He was about to walk away.
But yet, at the time of sentencing, there's not a shred of remorse for any of this. And that was more than 5 years later.
That once again
is definitely factored in, but the legislature didn't factor in a look-back provision. I mean, I agree that this court has that independent power, but in terms of relying on the legislature, they could have authorized a provision to apply here. But, Your Honors, I ask that you affirm. Thank you.
Your Honors, I'd just quickly like to address the excessive sentencing point. A 22-year sentence, despite how tragic what happened here was, a 22-year-old sentence for a 16-year-old with no prior criminal convictions is harsh and excessive and warrants reduction. There's a couple other aspects of the lead up to this very tragic incident that I want to emphasize. The prosecution's witnesses testified that Christopher was responding to threats to himself and his family. A 16-year-old would not have the life experience to assess the veracity of those threats, the emotional control to have a rational response to those threats, and even the ability to effectively evaluate the consequences.
Oh, I mean, I think that goes a little far, that no 16-year-old would have it, but I do agree that a 22-year-old sentence for a 16-year-old for a first offense is, but I mean, it wasn't just one stab. It was a lot of it was vicious.
He bludgeoned him.
Yes, Your Honor.
Absolutely bludgeoned him.
Absolutely, Your Honor. But, you know, as you mentioned, the situation had largely been de-escalated. According to witness testimony, it reflects a 16-year-old's, you know, emotional, general state, heightened state, you know, in the first place responding to threats. I'd emphasize if this even then had happened, less than a year before, his maximum exposure would have been 15 years to life. And that's where we're asking for a reduction to that now. He served 16 years since this incident occurred. That's almost half of his life and his entire adult life. And we believe he should have the opportunity to demonstrate growth in that time. He's 32 years old now, demonstrate that growth and become eligible for parole on that note.
Thank you. I want to thank you for your pro bono service on this case on behalf of the court and our entire system. And I also want to thank the people. This is a tough one.
Thank you.
And we will do our best to balance what is just on both sides.
Thank you, Your Honor.
Thank you. Osario versus New York Sandy 4.
Good afternoon, Your Honors. May it please the court. Brian Isaac, I represent the plaintiff appellant. I don't think this is as complicated as some of the other cases, so let me just give you my take on it. There's a huge difference between denying something and saying you have no recollection of something, and that's really my claim. If I'm walking down the street and an individual punches me in the face and I sue him, and I serve him, and I bring a summary judgment motion saying there's no way this person can under oath deny it, and I say, I knew him, he hit me in the face, I didn't do anything wrong, I was injured. If the defendant gives an affidavit which says, I know Mr. Isaac, I read his affidavit, I have no recollection of that occurring, could I possibly lose that motion for summary judgment? My answer is no, and that's the problem here. And quite frankly—
Can you address the plumber invoice?
Sure, it actually supports my position, not the defendant's position. Let me tell you why, Judge Kern. Go to page, there are two of them, so You can go to 852, which is what I have. Go to the April 9, 2019 entry, okay? 853 of the record, quoting it word for word. Truck dispatched to location for leak in apartment 2C, performed fixture tests in apartments 5C, 4C, 3C to locate source of the leak, okay? Fixture tests. Found no sign of leak after testing shower head, shower body, lavatory faucet, standing waste, and toilets. That's exactly what my client was saying. For 27 years, she broke it down not only by years, by decades, by months. She had constant leaks coming from the apartments above her. Go to the 416 repair 2 days after, which is also, I'm sure, what you're asking me. Page 852 of the record. Look at the difference. Truck dispatched to location to troubleshoot leak on C-line, opened up apartment 3C bathroom first. As per Gilbert, noticed 2 stack lines wet, opened in apartment 4C, and as well, line was still wet above, opened in apartment 5C and located broken section of pipe. That means they opened up the wall. That's exactly what my client was saying to do. And I find
So your argument is they neglected to do that on April 9th.
Yes, they neglected to do it all the time. The client's complaint was that they painted, they did a lot of ceiling work, but they never located the source of the leak. And I just want to give you one case, which I know you know because you know more about the cases than I do. I cannot see how this is functionally different from your decision in Dunn, DUNN against 6-8 St. Nicholas Realty, 204 AD 3D 466. The only difference might be that you found that what the defendant said was based on hearsay. But here I'm telling you the defendant didn't say anything. And don't trust me, Your Honors, look at pages 4 to 5 of my adversary's brief. Look at the terms he used. Didn't have a recollection of a memory. Didn't remember it. Had no recollection. That doesn't beat summary judgment in this case. If you have nothing else, I'll sit down and let my adversary talk to you. Thanks for listening to me.
Okay.
May it please the court. Mitchell Cohen for the defendants. The presentation on behalf of the appellant ignores the evidence and exaggerates imprecisely what has been presented and what the lower court understood. The record at page 853 included this in the plumbing bill. Tenant in apartment 2C, plaintiff, said tenant upstairs causes tub to overflow and leak below. Found tub needs to be grouted around floor of apartment 3C. So the tenant told the plumbers where to look.
That's what she thought. There's no way for her to know unless she's in apartment 3C.
She's in apartment 2 under 3C.
Right.
They tested on the 5th floor, the 4th floor, the 3rd floor. They found no evidence.
What did they test?
They tested.
On April 9th, what did they test?
What they tested were fixture tests in 5C, 4C, 3C to locate source
So
of
they
leak.
put the faucets on, the water came out, nothing leaked.
I don't know if that's correct, Your Honor.
Okay.
And there is no expert testimony what a plumber means by a fixture test. In addition,
So wait, so is your point that that evidence at least raises an issue of fact as to whether or not they adequately examined her?
Yes, Your Honor.
Yeah,
Of
okay.
course it does. And I would also ask the court to focus on what the lower court said about the testimony, because there were 3 deponents.
Was there any testimony, expert testimony from
None.
either side about the former leaks or whatever the old leaks were being the same leak that was, or the same source of leaks? There could be a lot of different sources of leaks in the
There's
bathroom,
no documentary evidence of any leak at any time, period. There is no expert testimony, period. But this is what the lower...
There were no records showing any repairs of leaks in the tenants' apartments prior to April 9th?
There is only deposition testimony, and discovery was completed without motion practice.
So her statements that I was complaining for years and years isn't reflected in any documents?
Pardon?
Is not reflected in any documentary evidence?
Correct, and we think the testimony is incredible. Keep in mind, this is a case where the plaintiff is lying in the bathtub and has a cousin there to take a picture. There are many inferences to be drawn here, judges. This is what the lower court said. According to Ms. Rodriguez, the super that lives in the building for a decade.
The one who had no memory?
No,
Of,
no, she had a
I don't
memory.
remember. I don't think we ever.
No.
No, I don't think they were
No.
ever. She never complained about any leaks. Yet on April 9th, there was a plumber sent to
Your
her
Honor,
apartment.
she did not say I have no memory. That's not what the lower court read. What the lower court read, she does not recall ever receiving complaints about leaks to plaintiff's bathroom ceilings or about repairs to the subject bathroom ceiling, except for repairs relating to minor leaks in plaintiff's kitchen, faucet, and bathroom sink. The same witness testified to painting in the apartment. So what you end up with is a brief on behalf of the respondents that have these sweeping statements about nobody remembering. And you heard here just moments ago a really outstanding lawyer who talked about constant leaks. I wrote it down. The burden of proof on a falling ceiling case is you show me the source of the leak. Was it the bathtub? Was it the broken pipe on the 5th floor? Was it somebody with a washing machine that they weren't supposed to have? All that's in the record. So, and I will say, as to the Dunn case, counsel was good enough to acknowledge that what this court said was there the defendant submitted hearsay. It's not what happened here, but I will tell you that if Dunn was so important, it might have been cited before the reply brief. Unless you have questions, Your Honor, I am complete. I respectfully submit the order should be affirmed.
Thank you.
Judge Scarpula, to your point, the testimony of Mr. Arroyo, and I'll give you the page references in a second, was that they had a computerized complaint system that was in place, that was supposed to record everything, that they never turned over, and that they never produced to the plaintiff. So there is a reason why there were no complaints, because that computerized system.
Yeah, but I mean, did you make any motions on that? Did you say I should, you know?
All I'm saying is, with respect.
No, but you can't say they didn't produce it if you didn't ask for it or you didn't make a motion to
I'm not talking
compel
about,
it.
it's not a discovery issue. What I'm saying is that in opposition to my motion for summary judgment, they didn't produce those complaints, which would have said there was never any complaints, here's the system, here's the apartment. They didn't do that.
No, because they don't have to make your bird now. You move for summary judgment.
I certainly
right?
did. And
So let me ask you this: how did that picture of the plaintiff in the bathroom come about?
I'm not sure. She was asked who took the picture. She wasn't sure, but it's there. It's certainly not a staged problem. And there were photos of that ceiling, 170 to 175, showing a hole of 4 by 4 feet.
Oh, I'm not doubting at all that. I'm just curious of how she was laying in the bathroom when
Well,
someone
she
came
said
down.
she was struck and she was in the bathroom. But I would point out to you that although my adversary says that the 4-9 repair isn't actually determinative, it specifically says fixtures and it specifically refers to fixtures. It doesn't talk about the wall. And the plaintiff said on page 508 of the record, okay, paragraph 10, assuming that that does create a question of fact, and I'm quoting, in the 5 days before my accident, I complained to Angela about the leak and ceiling in my bathroom daily in person. Paragraph 11, nothing was done to my bathroom. So even assuming that you find there's a question of fact there's an undisputed statement made by the plaintiff, not refuted by Angela, not refuted by Arroyo, not refuted by the husband. One other thing. The plaintiff, the superintendent also said that she would have had to have been aware of the plumber being present on the 9th because they couldn't come in without that. And when she was asked, what did the plumber do? She said her standard line 12 times, I don't remember, I don't know. That doesn't defeat summary judgment. Thanks for listening.
Thank you. Thank you. People versus Luis Felipe R. You may proceed.
Good afternoon, Your Honors. Will Page, Office of the Appellate Defender, on behalf of Luis Felipe R. The indictment in this case failed the most basic test of an indictment. It failed to allege every material element of the offense charged, criminal possession of a weapon in the second degree. Specifically, it omitted operability, and operability has long been known to be missing from the statutory text, but is yet an essential element. So by omitting it, the adjudication here has to be vacated and the indictment has to be dismissed.
Isn't operability something that should be established at a trial as opposed to be a requirement of the accusatory instrument?
No, Your Honor, if it has to be established at trial, if it's an essential element of the offense, then it also needs to be in the accusatory instrument. That's actually the unknown test, is that every material element of the offense needs to be in the indictment.
So the indictment has to say that he was in possession of a firearm and that the firearm was operable? Is that what you're saying?
And loaded, yes, it does need to say all of the elements, Your Honor. And so...
Didn't the indictment here include the CPL 120, which defined what an armed felony is, which includes a loaded firearm capable of producing death of serious injury? Why doesn't that satisfy the requirements that you are referring to?
I know a respondent would like that to save the deficiencies in the indictment, but there are two subsections to that definition, right? There's subsection A, which deals with operable weapons, and there's subsection B, which deals with just the display of something that looks like a weapon, and that would clearly also encompass inoperable weapons. So again, I guess it's been almost 30 years since Longshore made clear that operability was a material element of these offenses. It's not hard to put operability in the indictment, or when you cite 12041, to cite 12041A if you're dealing with operability. We can't just breathe in a material element out of fiction, and we can't expect Luis to just figure out which one he's supposed to know. And I think that's why this court's decision in Winston is so important, and the Winston indictment is attached to the reply brief. But there, the statutory text actually included dangerous weapon or a dangerous instrument, and the indictment cited to that statutory provision, but this court said that because there was no allegation of that material element, then that count was jurisdictionally defective. So really, we're just on all fours with that analysis.
What's the case?
People versus Winston.
No, I mean, I think I was on that case. I think it was about an amendment to the indictment that was the problem there, not the indictment itself. And here, the allegations are directly with respect to 265033, right?
It did, Your Honor. Winston did deal with an amendment to an indictment, but if the language directly from Your Honor in that panel is that the court was correct to decline amending the indictment because of the missing factual allegations, because the instant indictment failed to allege the deadly weapon or dangerous instrument, which is what rendered them jurisdictionally defective. It was always jurisdictionally defective, right? That was the premise that Your Honor on that panel and the Winston court was operating from.
It wasn't argued that what you are arguing now was not at all argued then. That was not argued even that it would be jurisdictionally defective to incorporate the parts of the statute.
Oh, I'm sure incorporation was not argued in Winston, Your Honor.
Right, and
I don't think
that's what you're arguing, that is insufficient here. That was not argued in Winston at all.
Well, and I'm sorry, but my time's expired, but just to quickly address it, but I'm sure Your Honors were aware of People versus Cohen and just knew that People versus Cohen did not operate in that case.
Nice try. Nice try. You may proceed.
Good afternoon. May it please the court. Charles Hickerson for the people. Your Honors, I would just like to cut to the heart of the matter about this, which I think is notice. That's one of the three primary purposes of an indictment historically. The implication here is that defendant didn't have notice that he was charged with 265.03 sub 3. That's refuted by the record. At the plea allocution, page 16, the defendant admitted that...
Well, we can't go to the allocution to determine whether you properly charged.
Of course, Your Honor. I just wanted to point out that both defense and defendant during the allocution admitted to operability and admitted to receipt of the ballistics report that proved operability. But even
that's not the issue, and you know that's not the issue. We're talking about at the inception, the charging documents.
Yes, Your Honor, and to get to those charging documents, as Your Honor has correctly pointed out, and as Cohen pointed out, the allegations were made out sufficient for the CPL through incorporation by reference. Cohen said that incorporation by reference to the statute will be enough, and it's enough for any judicial gloss laid therein. In this case, Your Honor, we mentioned a loaded firearm in the indictment and 120 of the criminal procedure law. Now, you all already spoke about 120 of criminal procedure, so I won't go over that again, but I will just point out that loaded firearm, as defined by 265.00 sub 3 sub 15, loaded firearm is defined as any firearm loaded with ammunition or any firearm which is possessed by one who at the same time possesses a quality of ammunition which may be used to discharge the weapon. Essentially, Your Honors, it's inherent in reference, and I do think it's interesting that this is a 2014 case, and in that time since, as Your Honors are aware, the Bronx has indicted plenty of gun cases, and this is the first time I've seen this argument made. Unless Your Honors have any further questions, I'll rest on the brief.
Thank you.
Thanks.
Okay.
Starting with the last point, Your Honor, loaded, as just defined, does not mean readily capable of discharge. It just means that the ammunition could be fired if the gun was operable, which is the missing essential element.
But that's not in the statute, right? And then
operability.
in Winston, it was something that was in the statute that wasn't in the original indictment, correct?
And that's precisely why Cohen can't save this, because Cohen allows you to incorporate things that are in the statutory text, but this is not in the statutory text.
So you're saying that he wasn't given fair notice of what he was charged with?
Well, as the Court of Appeals in Sickenger recently reiterated, the three important functions, notice is one of them. And I would submit to you that Luis was young, and he may not have known, based on this indictment, what to talk to his attorney about. He may not have known operability was at such issue. But the second critical function of an indictment is that you have proof that the grand jury considered every material element. And if you miss a material element, you no longer have that proof. And it's for that reason that Cohen doesn't save this indictment, because you just don't know what the grand jury did here. And in fact, we have some real questions about that, because the later filed bill of particulars isn't filed until September. This is a March indictment, and that bill of particulars says that the gun was later found to be operable. So we don't know what the grand jury saw. And I would just close by saying that respondents don't contest our mandatory surcharge issue. Thank you, Your Honors.
Last but not least, Magna Equities versus Writ Media. You may proceed.
Good afternoon, Your Honors. Scott First, Sickenger Ross Ferentz for the appellants in the 2020 appeal and the respondents in the 2022 appeal. About 3.5 years ago, the trial court issued a judgment confirming a 61-page report and recommendation that provided for an extensive amount of detail, and in particular, actual damages being awarded to the appellants in this instance of $880,000, $3.954 million in liquidated damages, about $274,000 in attorney's fees and some costs. The matter was set down for a money judgment to be entered thereafter, because the underlying report, which the trial court order said it saw no reason to adjust, which also provided for joint and several liability for the respondent's signature stock transfer, only calculated those monies through the time of an inquest, which had started in 2017 and went through April of 2018. And so, as per the recommendation in the underlying report and recommendation, it encouraged the trial court to allow the appellants in this instance to amplify the record through the entry of judgment. 4 months later, that was it. Order issued, notice of entry, and 4 months later, a money judgment comes out. The money judgment reduces from $880,000, the actual damages, down to $188,000. It throws out all of the liquidated damages. It says no damages can be awarded against one of the two respondents, and says there's no joint and several liability as to that individual. In reducing the actual damages...
Before you continue, am I correct that prior to receiving this reduced judgment, that Judge Sherwood requested submissions?
Yes, it is specifically... Judge Sherwood
Explain to me in what context that came about, and what did you believe that submission was for?
Sure, thank you. The answer is yes. There were 2 phone calls that were conducted. One, I believe, was in or around May of 2020, and the second one was in July of 2020. These were telephone calls, which counsel participated in with the court's attorney, Ms. Sarah Cranston. The judge was not a participant. She asked for, as the charge was, to amplify the underlying calculations, because the motion to confirm had said, give us the calculations as they were set forth in the underlying report and recommendation, which the trial court reported. And so we did so. There was a difference, and you have this in 2 different parts of the underlying...
Let me just ask you, in the report that was confirmed by Judge Sherwood, liquidated damages were upheld, correct?
That is correct.
So he confirmed that, and the amount of damages was confirmed, correct?
All correct.
And did anyone make a motion to re-argue the confirmation of the referee's report?
I believe that the answer is yes. There was a motion that was made on April 13th of 2020, which was the second of, I believe, 3 leading to ultimately...
And what happened to that?
All denied.
It was denied.
Every motion to renew...
And was there any appeal from the original motion confirming the referee's report?
I'm not aware of any appeal.
Was there any from the... Well, you couldn't appeal the denial of re-argument, right?
I'm sorry.
You couldn't appeal the denial of re-argument, but...
Well, the confirmation was in support of my...
no, that's what I'm saying.
But there was not. There was an original...
No appeal, no granting of re-argument.
Correct. No motion before the court.
I'm not clear, what were the submissions for?
The submissions that were ultimately submitted, and they are in 2 locations, and I want to tell you the precise
it's okay.
page
Just
numbers.
Tell me, what were the purpose of them?
The purpose was supposed to be for purposes of amplifying the calculations that were adopted in the confirmation of the underlying report. The appellants submitted those numbers, and in response, the respondents submitted briefing. They submitted arguments in law and others.
Why was the court not allowed to do that? What was inappropriate about the court doing something different in the judgment than it did in the original motion to confirm the reference report? Why shouldn't we allow the judge in his discretion to change his mind and do something different?
I thank you for asking that. It is, I think, very settled law that when a judgment completely departs from its underlying order and exceeds that which was in there, and it's not on motion, and it's not on any particular notice to the parties for briefing of any particular fact, it's fairly settled law in this department and in the state that that's improper, because the judgment must conform to its underlying decision and order. It can't suddenly abandon all of it. It can't even do so for many of the reasons cited in our underlying briefing papers. It doesn't matter if it's we no longer see the logic of it, we've forgotten the logic of it, we want to reverse on something else. In this particular instance, the underlying report and recommendation went to incredible detail as to all of these elements. It went into detail on the liquidated damages provisions, which did grow to a very large number, and explained that they produced no evidence and that it was always their burden. And we cite all of that, from Truck Rent Center all the way through Seymour Hovnanian, JMD Holdings, 225, Fifth Avenue. These are all cases coming out of this court, including Seymour, which was just last year, where they said that the party seeking to avoid liquidated damages has the burden to prove that. That was all cited in the report and then adopted in the
we don't even have to get to the merits, that the court exceeded its authority, it didn't have any authority, the decision was never appealed, and we should reverse because the judge didn't have the authority to issue that.
That is the case, and in response, what you have are, as we noted in our opposition to it, we cited to 40 different authorities from the Appellate Division, Court of Appeals, as well as New York federal courts sitting in New York federal courts that have interpreted these issues, and every single one of those sets forth the limitations on the ability of the trial court to essentially act as a revisory or appellate, exercise revisory appellate. And they said, you can't do that. None of that was addressed. 35 out of 40 are completely skipped in the underlying position. I realize my time is out. We didn't get to the 2022, so if I may reserve
that on rebuttal.
Thank you so much.
And since he went over by 2 minutes, I'll give you 2 extra. Okay?
I'll try and be as brief as I can, and thank you for your patience. With regard to the issues that were just being discussed, there was no motion to re-argue. There were motions to renew that are not relevant to this issue.
Why did the judge have the authority to do what it did? There was a motion to confirm. The judge confirmed the report. There was no re-argument. There was no renewal. There was no appeal. What gave the judge the authority to go back in the form of entering a judgment, which is just to confirm to what was in the order, and all of a sudden come out with a completely different decision, which in effect did not confirm the report?
Sure. First of all, there wouldn't be an appeal because there was a decision, and we were waiting for the judgment that would be entered in response to that decision.
No, you could have absolutely appealed.
But there's no time. This all happened fairly quickly.
The point being, there was no appeal, there was no renewal. What was the authority for the court when all it was supposed to be doing is entering into a judgment to conform to its order to all of a sudden issue a completely different decision, which completely altered the underlying result?
I understand. It has to do, the reality is it has to do with the way this all happened. A default was taken against the defendants when their attorney had a stroke. Judge Sherwood issued that default. At the time, he didn't analyze the complaint. He didn't analyze the claims. That's the reality of what happened.
You're giving the reality of why he might have done what he did, but that's not
I understand.
Can I ask why? What's the court's authority to revisit?
And I'm just, why did you submit a judgment that didn't conform? Perhaps if you tell us why you submitted a judgment.
I didn't submit a judgment that didn't conform.
Oh.
What happened is after the court issued its decision, the decision required the parties to settle the judgment on notice. We settled the judgment on notice. The plaintiff submitted a judgment. The court arranged, we responded to it. The court had a conference about this. And the judge expressed its concerns that it no longer felt that the...
But your opposition wasn't it attempted to relitigate all the issues all over again.
All my opposition...
It wasn't a counter proposed judgment. It was this decision is wrong, let's do it over, kind of.
With due respect, we submitted a judgment, a proposed counter judgment, and we submitted an affidavit as to why our judgment better reflected what the special referee had...
Your judgment clearly did not reflect what was decided before. It was completely different. I still haven't heard an answer to my question. What was the authority for the court at the time of the judgment to revisit what he had already decided when he confirmed the motion, the referee's report?
The process, when the judge directed that the judgment be settled, that meant that the circumstances were not final, that the judge was trying to sort it out.
No, that's not what that means.
That's
not what that means.
That's all I have.
We settle judgments on cases every day of the week in New York State.
But the reality is,
It only means that the judge does not have a long-form order that would conform because of the particulars of the case. But the judgment that was signed does not reflect, do we agree, that the judgment that was signed does not reflect the referee's report?
That is correct. I don't dispute the fact.
So again, under what statutory authority is a trial judge permitted to confirm a referee's report and then, without a motion to re-argue or any reversal of that confirmation, enter different numbers? Do you have any statutes that say you can do that?
I do not.
Do you have any cases that say you can do that?
All I have is the arguments that we put in the brief.
Which are?
Which are that the judge, court, absolutely the court changed its mind. There's no question about that.
Okay.
With respect to the judge, quite frankly, just focused on the situation and came to a different conclusion. That's exactly what happened.
Is he allowed to
and
do
the point
that?
excuse me, the point that I made, though.
Just ask the question.
Is he allowed to do that?
I'm sorry?
Is he allowed to do that? Just change his mind?
If the judge was not allowed to do that, the issue would still be before this court as to whether or not liquidated damages and penalties can be awarded.
Why is it before us? Why should, it's a question I asked for, why should we get to the substance when the court, if the court went beyond its authority in ever considering the underlying substance once it confirmed the report? Why should we basically allow an indirect appeal where there never was an appeal?
I'm not sure I'm answering your question, but I'm going to try. If the judge had entered a multi-million-dollar judgment, we would be appealing here from that multi-million-dollar judgment.
And that would be the appropriate course.
So Your Honor.
That is what should have happened.
Fine. So if Your Honor's reverse and remand for entry of the larger judgment, we appeal from that, and we're back before you with the appeal.
I mean, that's for another day whether you can still do that. But
well,
the only question is whether the trial judge had the authority to essentially change his mind without a motion to re-argue, without granting a motion to renew.
As we pointed out, however, the equities of this, we pointed out, however, that there was extensive discussion and submissions on the issue. And so there was no surprise to anybody that this would happen. I just want to add one more thing in, please.
The fact that it's not a surprise doesn't mean that it's authorized.
Isn't ultimately the question, though, the interest of justice is to get to what's the right result?
The issue was the proper procedure followed. We don't just haphazard go about the law. We have procedures in place for a reason.
I understand that. But nonetheless, we're trying to get to the right result. This thing has been going on for 7 years. They've been asking for multi-million-dollar judgments on loans of $85,000. That's where we're trying to get to the end of this thing. We're not trying to get this thing, we've been trying to get this to an end.
Well, I mean, when the loan was granted, right,
I'm sorry?
You consented to the terms of the loan, right? It's not like
there's no question that we consented.
You consented to the $2,000 a day, and you consented to all the other terms of the loan, correct?
All of which, as a matter of law, are unenforceable.
No, but did you put that? I mean, you put all of that before the referee, right?
I'm sorry?
Put those arguments before the referee.
Absolutely not.
Okay. Well, how come?
You are talking through your rebuttal time, just so you know.
All right.
All right. That's okay.
It was an inquest. We weren't allowed to make any defenses. We weren't allowed to put any of this before the referee.
Because you defaulted.
Excuse me?
Because you defaulted.
Because of the attorney's stroke, exactly.
Mm-hmm.
So we were dealing with the procedure and the situation as it arose. I do want to add one other thing, though.
You are out of time.
Can I just cite
Counsel,
a case that...
Counsel, have a seat. You're out of time. Please.
Thank you.
I've given you, you've gotten like double your time. 1 minute.
I'm sorry, you giving him another?
No. 1 minute.
Okay. Very briefly, the 2022 appeal, which we are the respondents on. It distills down to this. They are essentially looking for a fourth opportunity to file their third motion to renew a prior motion to vacate a default. They do so under the premise that the 2021 decision by the Court of Appeals in Adar Bays should control because it's new law. That decision expressly states it's not new law. The civil and criminal usury statutes have been on the books for probably the age of all of us or a lot of us combined. There's nothing new, and it expressly rejects that in addressing the underlying dissent. But it also says the following thing. The burden of establishing a usury defense lies with the defendant. And if you don't plead that and you don't prove that, that's it. They want the court to believe that just because this case was decided and in contravention of years of litigation and a very clear record, that Adar Bays has some reach when the unusual, I dare say, perhaps even an anomaly of a fact pattern, in this case, is that there is no usury that was ever pled because there was no answer. They never moved to file a late answer to compel the acceptance of a late answer. They moved multiple times to dismiss, all unsuccessfully. They even moved 3 times in the underlying record to try and vacate. They attached 2 draft answers that didn't contain any usury defenses. It is something akin to a Hail Mary pass, but this is not the place to be doing that, and it's a gross distortion of what the reach of Adar Bays is supposed to be. I asked the court to reverse so much of the 2020 appeal that had the effect of taking out the actual damages, as well as the liquidated damages, as well as the confirmed joint and several liability as against both the respondent Writ and the respondent signature stock. And as to the 22 appeal, I asked that the court affirm the trial court's denial of the motion that was made by counsel. Thank you so much.
Counsel, please give the citation of the case that you have to your adversary and give the citation to the court officer, and she will deliver it to us. Okay? Thank you.